Number 24, my lord. After my lord, what's the name of the take up the
Yes. What do you want?
not the take up this the problem, my lord, it's the auto sort of
Western careers. What I have to do?
lordship. Okay. I've been informed that there is a notification saying that in matters that Dr.
Dr. Saraf is appearing. But the problem arises when he's not there. He's a senior counsel. Unless his name is not shown, how do I do it?
The first that he has appeared. The order sheet.
Or is it? Oh. Okay. Item number 24, list before any other bench.
But in the item number 48, I file Friday, I may be allowed to file.
I don't know what is the lordship.
Oh, wait. IA filed, IA will have to be listed.
For party reading,
Whatever may be, IA has to be listed. It cannot be like this. It will have item number
48,
48.
supplementation. The lordship was pleased to fix today on the Friday.
That's
itself,
true.
I
But
filed.
the IA has not been listed. You filed today.
No, Friday. Friday.
It has been submitted by Mr. H. Das, the learned counsel appearing on behalf of the petitioner, that an interlocutory application has been filed in the instant proceedings. Just to list this matter again on tomorrow on Kali date to review,
Filing serial number.
including bringing on record the said interlocutory application.
Filing serial number. I have it.
I don't know what is the lordship. I don't agree with that. May I pay for the listing of a petition for eviction, your lordship? Or if it is not.
Why?
The urgency is that we are challenging the election of two directors of a cooperative society. The minutes have been approved, but they have not yet taken over charge. Our apprehension is that if we take over charge, then our prayers will be rendered invalid.
Okay, we take it today.
Very well. That's why we got the item number 16, the matter is taken in fact,
16.
61.
Mr. M. Sahiwala, the learned counsel appearing on behalf of the petitioner, submits that that he has been instructed. He submits that the writ petition has become infructuous. Accordingly, the instant writ petition stands closed as it had become infructuous. Interim order, if any, stands again.
Before lordship, for item number 29, my lord, as Mr. Ganeshik got some personal difficulties to argue this case today, my lord.
29. Okay, this is the matter after vacations.
I beg to mention item number 47, my lord. And petitioner wants to withdraw it.
To withdraw করাই দিব। Mr. S. Hook. Withdraw interim order if any vacate.
Okay.
Yes, Mr. MJ Babu.
For listing of the case, my lord, motion was filed on Friday. So
Come up tomorrow. It will come up. Won't it come up? Why do you have to mention it?
well, please, your lordship. I beg to pay for listing this to my lordship. The petition.
For?
Orders, lordship.
No, not before vacation. After vacations.
With your blessings. If I'm paying for an adjournment in item number 28, my lord, the ground that we're not able to contact the clients, my lord, we will write a letter.
Item 28 to be listed after vacations.
Much better. Please, your lordship. Also, I take to mention item number 10. On item, we need to bring some additional documents and readings on the record. May I be allowed to file an IA also?
Fine. You want the adjournment, the item number 10, to be listed after vacation? After vacation.
Please adoption. Item number 31 and declaration item 30, we have filed an IA to the adoption. It's not on record.
Item number 31, it has been submitted that the Miss, what's your name?
Each push.
Oh, this matter. What I,
Regarding correction of the cost item in the adoption. Correction of the cost item.
forget about that. What
Uh,
is this matter otherwise for? Here, we are concerned about taking that particular document out there. We will look into it. Don't ask. These eyes are meaningless.
Okay, sir.
May I please, Your Lordship? Lordship, I beg to mention for listing a WPC for admission, Lordship. Lordship,
After vacation. No, what is the urgency?
Lordship, the matter going to be, the duration of the matter going to be.
Huh?
Duration of the matter, Lordship, matter relating to PMI Pakka construction. Lordship, matter going to be ended on by this year, Lordship.
They've demolished.
Lordship, Pakka construction, the all are the Lordship, petitioners are accepting petitioner, all are already get the Pakka construction. Lordship, accept the petition.
Huh? After vacation. No heavens will fall. Not now.
Lordship, date,
No, nothing now. Make it mention next week on the reopening. There will be a more kinder judge on the reopening in this bench.
let's
Your Lordship. Lordship, I beg to mention item number 13, Lordship.
13?
Mr. Council is on leave. Because due to his brother's treatment, Lordship.
What happened?
The treatment, medical treatment.
Who?
Mr. Ega Police.
A.K. Purkastan. What happened to him? The whole matter. We'll see when the matter reaches. If it is a case of dismissal, I'll adjourn it. Otherwise, no. No adjournments at this. 2015 matter. Sorry.
Maybe possible for the.
No, nothing. Doesn't looks nice, no? 2015 matter. You want to have a decade anniversary next year? Nothing doing. Yes.
Lordship, prayer for listing a matter for tomorrow. Lordship. So, Lordship. For the list, item 1.
Mr. Das, why don't you file an affidavit in respect to the queries made in the order dated
Why not?
29/8/2024?
Operan about my lord, there are already two petitions have already been disposed of by this honorable court, my lord. Their record also may be called for, my lord.
Which one?
Because the same prayer is made in this present petition also, my lord.
That we'll look into it. I know what is
Well,
there. That is on another aspect. I've seen the
Well.
order. You file a reply to these two questions which I have raised in the order dated 29/8.
That.
List
Yes,
this
I-
matter again on 4th of November 2024. In the meantime, the respondent number 2, 3, and 4 are directed to file an affidavit in respect to the query raised by this court in the order dated 29/8/2024.
Interesting, lords, ma'am.
Item 2. Yes, I have received instruction.
may I please.
Tell me,
Let me file my affidavit in opposition, Your Lordship.
What instructions?
It's a time bar decision.
That I've recorded it in my order earlier. Okay. File your affidavit.
Item number 49 also, it's also similar, Lordship. Lordship, item number 49.
49 will come when 49 reaches. B.N. Gogoi, appearing on behalf of the respondent authority, submits that he has received his instructions and as such instruction, and he would like to file an affidavit in that regard. Was taking into account the above, this court fixes this matter again on 11th of November 2024. The affidavit has to be filed by 4th of November 2024. The petitioner would be at liberty to file any reply thereagainst. List accordingly at the top of the list. Interim orders passed earlier shall continue in the disposal of the petition.
Motion item 3.
Yes, what is this? Anything?
Extra.
Hmm.
But it's really slow.
See?
Second page, Lordship.
Budget has been released. You'll get it from the DPU.
Okay, then.
Heard Mr. S. I. Akan, the learned counsel appearing on behalf of the petitioner. I have also heard Ms. D. Athorika, the learned counsel, standing counsel of the Revenue and Disaster Management Department of the Government of Assam. This court, by an order dated 11/9/2024, requested Ms. G. Hazarika, Gina, to obtain instructions from the respondent as to whether the order dated 13/9/2023 passed in WPC number 3389/2023 have been complied with or not. Today, the learned counsel appearing on behalf, the learned counsel has placed before this court (13/9) or 27/3.
39.
Okay. Inaroy na? That completed an instruction issued by the Joint Secretary to the Government of Assam, Revenue and Disaster Management Department, dated 24/9/2024, wherein it has been mentioned that in compliance to the order passed by this court, the Revenue and Disaster Management Department have released the budget allotment of ₹6 lakhs at the rate of ₹2 lakhs each to the next of the kin of Swaraj, na? Of late Swaraj, and have released the budget allotment of ₹2 lakhs for the next of the kin of late Swaraj Chandra Lal to the DDO concerned by online budget for making payment of the ex gratia payment to the petitioner for the instant case. The said instruction is kept on record and marked with the letter X. Full-stop. Taking into account that the amount of ₹2 lakhs to which the petitioner herein would be entitled to has already been released to the DDO from the counsel for the petitioner submits that he would not like to press the instant contempt proceedings. Accordingly, the contempt proceedings stand stopped. For
Lordship, in this matter, Lordship has asked me to have the instruction. This is as regard Sokola Ami Madrasa and also the Anganwadi centers which were situated in the vicinity of it. So demarcation process has been called for in the previous writ petition. So finally, a task force has been constituted and the petitioner now in the contempt claims that no further development has happened in this case. So now I have got the instruction immediately after the task force has been constituted, proper demarcation process has been initiated and the area of land within possession of these two institutions are already demarcated.
demarcated.
Yes.
But so far my
Srinath,
section
Srinath.
is concerned with that.
Srinath.
So far I have the information here. But no such demarcation has taken.
No,
place.
this is the circle officer's report.
ঘৰবস্তি আৰু ফিচাৰী হিচাপে 4 বিঘা 1 কঠা 11 লৈছে। মাদ্ৰাছাৰ দখলত আছে 2 কঠা 11 লৈছে। মণ্ডল অংগনবাদী কেন্দ্ৰ মডেল কেন্দ্র আছে একঠা নল আছে রাস্তা হিসাবে ব্যবহার আছে একঠা 17 লেছে টোটেল 5 বিঘা 2 কঠা 7 লেছে ভোটাদাৰৰ মুঠ জমি 5 বিঘা 5 লেছে বাকি 2 কঠা 3 লেছে
No, my lord, our case is that the construction has been started in our land. If your lordship is pleased to fill the last line, অন্য হাতে আনহাতে সকলা আমি মাদ্রাসাৰ দখলত থকা জমিত 1 কঠা 4 লেছাৰ অংশত 30 নং মডেল অঙ্গনবাড়ী কেন্দ্ৰৰ নিৰ্মাণ কাৰ্য প্ৰস্তুতি চলা দেখা যায়। So that was our grievance.
No grievance
So
has been,
that part has not been vacated.
oh who is going to vacate
No, but at least
no do you want the revenue authorities to vacate it?
no, my lord, because if the
No, Mr. Council, kindly don't come up with all these aspects. A demarcation is to be carried out only to show which are the boundaries of which tract and what is the existence of your rights. Not to get into possession. If you have any problem with the possession, go before the civil court.
that of course, my lord.
Then
But so far as my information is concerned, my lord,
no
no
information.
such process was carried out, my lord, till date.
This is done.
My lord, officially they may show that yes, we have done, but in fact, no officials visited, only except my lord, the constituting this task force.
This has been done. If you have any problem with it, you have to go to the civil court. So this is what it is happening. Pottadara Mudh Zamin is this. I have this amount. This somebody is encroaching. This is the document. Good. Matter over. Now, pursuant this court by an order dated 11/9/2024 had requested Mr. S. Burwa, the learned junior government advocate, Assam, to obtain instructions as to whether the order dated 19/4/2024 passed in WPC number 6117/2023 have been complied with or not. In response to the request so made, Mr. S. Burwa, the learned junior government advocate, had placed before this court an instruction to the effect that the demarcation was carried out on 1/6/2024, na?
yes,
Was carried out on 1/6/2024. And the details of which could be seen from the certificate given by the circle officer, Borkhet Tree Revenue Circle, to the
ATC Nolbert.
additional district commissioner, Nalbari, dated 14/6/2024. Pusto. In addition to that, he had also placed before this instruction, placed before this court an instruction in support of the said document issued by the circle officer, Borkhet Tree Revenue Circle, is kept on record and marked with the letter X. Taking into account the above, this court is of the opinion that the order passed by this court dated 19/4/2024 in WPC number 6117/2023 have been duly complied with. Pusto. The petitioner herein would be ipso aggrieved by the area, ipso aggrieved by the possession over the land in question by other third parties. The petitioner would always be at liberty to initiate appropriate civil proceedings.
I'm obliged.
Contempt proceedings accordingly stand strong.
Right.
Yes,
Page number 26 is the order also. 90 days time was given,
page number,
26.
what is the order? And made by the council proposes to council to dispose of the repair with the direction to the imam to dispose of the representation submitted by the strictly in the light of the provisions contained in insurance. As committee insurance shall dispose of the representation dated imam submitted by the petitioner by speaking order after hearing the petition. All the exercise will be completed within 90 days. Then
Then this order was communicated by way of registered post, but no decision was taken. Thereafter,
it was
Copy of-
received on 13th of July 2024. Order was passed when?
in 60/2020.
Kudukundu, 52. Tell me, use,
Three
it
2000.
was received on 19/7/2024. 90 days is over? How?
Order was passed on 60/2020.
Mr. FZ Muzumdar. Page 29, it shows that it was received on 19/7/2024. 3 months, 90 days would be over when? Don't come.
Before that, I had communicated the order by way of registered post and
No, first of all, this receipt shows on 19/7/2024. It is a premature contempt petition.
Lordship,
We are yet to get 1910.
Lordship, another aspect,
No, nothing there expect. Then other than that, which are the other document to show that it has been submitted to the Hajj committee? This is the document received on 19/7/2024.
Lordship, this page number
Therefore,
27.
no,
I may be
nothing
allowed,
doing.
I may be satisfied the code, Lordship, only 1 minute. I'm just taking 1 minute,
Tell
90
me, tell
90
me.
seconds. This order, it is says that that not after the receiving certified copy. It says the council was present. It says the speaking order is to be passed after 90 days from the date of the passing of the order. Even then, the communication is not necessary also in term of the order. Last paragraph, Lordship of Fellows.
Yes, who was appearing out here? Where is Mr. DJ Das? Is the central government council.
Yes.
Get hold of him. Get hold of him.
Yes.
Then we'll pass for.
Okay.
I don't issue contempt just for the sake.
It may be taken after sometimes. No, no, no.
Get hold of him.
Item 6.
নাম দেখাইছে নে? 100 নাম দেখাইছে নে? লিষ্টত সব নাম দেখাইছে নে? দেখাইছে নে? None appears on behalf of the petitioner on call. It is seen that on the earlier occasion also, when the matter was listed on 23/9/2024, none has appeared on behalf of the petitioner. Taking into account the above, this court closes the instant contempt proceedings as not missed for non-prosecution. Accordingly, the instant contempt closes the instant contempt proceeding for non-prosecution. 7.
I want to withdraw this petition.
Lordship, Mr.
I want to withdraw this
uh,
petition.
from-
I want to withdraw this petition.
Better. Oh, this one. Side. Schedule B.
Private property.
Mr. Sina, the learned counsel appearing on behalf of the petitioner submits that the petitioner would not like to press the instant petition. Accordingly, the petition stands closed.
Liberty.
What liberty? What liberty? You don't get liberty just for the sake of it. No, nothing. You don't withdraw. Why you're withdrawing?
Some document regarding position of this net Miller. There was in appeal Miller, and the injunction was there Miller, but order is not with me.
You go file civil suit. If they are sealing it, whatever may be, file civil suit. But they you no liberty. Liberty does not. Right? I've taken this matter twice. Twice you have not been able to satisfy this.
Such document has been provided. No such document has been provided me that earlier council there.
No. You want to withdraw or no liberty? What do you want?
Which one? Already.
Yes, Mr. B. Sinha,
Yeah.
again another case. Now, what did you make correction again?
There is improvement by the registrar Cotton University.
Cotton University. This is an application filed by the petitioner seeking implement of the Cotton University as a party to the instant proceedings, taking into account that it is at the behest of the Cotton University, the impugned notice was issued. Notice, na?
Yes, sir.
Taking into account the above, this court is of the opinion that this is a fit case for impleading the Cotton University unit represented by its registrar having its office at Panbajar, Guwahati, 781001 in the district of Kamrup, Assam, as the respondent number 4 to the accompanying petition. The petitioner is directed to file a fresh memo of parties before the registry of this court within 2 days from today. The registry shall, on the basis of the said fresh memo of parties as well as instant order, make necessary corrections in the cause title of the writ petition as well as update the same in the CIS. IS stands disposed.
I'm for the Cotton University, man.
Fantastic.
I'm representing Mr. P.D. Nair. We haven't received the copy of the IA file.
Not necessary. We heard, Mr. Counsel, we are yet to issue a notice. So take your seat. Either are you on caveat? Have you filed your wakalatnama? Then we have nothing to do. We see Mr. J.C. Hendrick out here. Kindly give him the way. Yes. Wait. Main case? Order? Issue notice. Making it returnable on 4th of November 2002. On 30th of October 2024. 30. Ms. D. Hazarika appears on behalf of the respondent number 1. Mr. Mr. J. Hendrick appears for the respondent number 2 and 3. As the respondent numbers 1, 2, and 3 are duly represented, extra copies of the writ petition be served upon them during the course of the day. As the newly included respondent number 4, the petitioner is directed to take steps by way of registered as usual and by usual process during the course of the day. In addition to that, the petitioner is also directed to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. Next. The case of the petitioner herein is that the petitioner, number 1, has possession over a plot of land measuring 1 kata 5 lechas, which is covered in tag number 279/280 old /1116/1883 new of Revenue Village Ulubari under Moza Ulubari in the district of Kamruk. The case of the petitioner is that the said plot of land, the possessory right of the said plot of land was purchased and thereupon the petitioner had constructed an Assam type house therein. The case of the petitioner number 2 is that he had been in possession of a plot of land measuring 1 kata 10 lechas since the last 40 years, which falls within dag number 280 old /1116 new of Revenue Village Ulubari, Moza Ulubari in the district of Kamruk, Assam. In the year 1984, the petitioner's husband had purchased the possessory right of the aforesaid land on payment of valuable consideration and have also constructed an Assam type house thereon. It is the further case of the petitioner that both the petitioners filed settlement applications. Both the petitioners submitted settlement applications before the concerned authorities seeking settlement of the said government land. However, it is the further case of the petitioners that on 9/8/2023, a notice was issued by the Circle Officer, Guwahati Revenue Circle, to various persons, including the petitioners, informing that on the basis of a petition filed by the Register of the Cotton University, Panbajar, and the report submitted by the Latmandal on 30/8/2023, hearing will be fixed to a hearing would be fixed, and accordingly the petitioners were directed to appear before the Circle Officer, Guwahati Revenue Circle, Guwahati. Pursuant to the said notice, the petitioners have duly appeared before the concerned authority on 30/8/2023 and had also submitted the requisite documents. It is the case of the petitioner that nothing has been mentioned thereafter. The petitioners are unaware of the fallout of the said hearing. However, recently, in the month of September,
December 23.
December 2023, what happened?
Land staffs have come, land staffs have come to evict us, my lord, but we have resisted not to evict.
Now, why did you have come before this court in
Because-
September?
Anytime they may be evicted, my lord.
However, The pursuant thereto, the the persons from the revenue authorities, the officials of the revenue authorities have been threatening the petitioners time and again. And it is under such circumstances the petitioners have approached this court. Mr. B. Sinha, the learned counsel appearing on behalf of the petitioners, submits that if the land in question had been allotted to the Cotton University, the summary mode of eviction as conceptual summary mode of eviction in terms with Rule 18 of the rules of the settlement rules under the Assam's Land and Revenue Regulations 1886 would not have been applied insofar as the petitioners. The Cotton University, he further submitted that the revenue authorities have no business for the purpose of seeking eviction of the petitioner, and through the revenue authorities have no business in respect to the land if allotted in favor of the Cotton University to initiate such summary eviction. The learned counsel submitted for this in elaborating the said submission while further elaborating his submissions contended that if the Cotton University wishes to evict the persons, the same has to be done by following the due process. Taking into account the above, Mr. J. Hendick, the learned counsel, J.C. Hendick, the learned counsel, appearing on behalf of the respondent number 2 and 3, submits that he would like to take instructions. Taking into account the fact that from the notice stated 9/8/2023, it prima facie shows that it is at the behest of the Cotton University, that is the respondent number 4, the circle officer, Guwahati Revenue Circle, have initiated the proceedings. And the petitioner have an apprehension in view of the stand being taken by the revenue authorities that they may be evicted. This court is of the opinion that till the instructions are received from the respondent number 2 and 3 as to the fallout of the proceedings initiated by the notice dated 9/8/2023, and under what circumstances such actions are being taken by the revenue authorities. It is the opinion of this court that the interest of justice will be met if certain interim orders are passed. Accordingly, this court directs that the status quo as regards the possession of the lands in occupation of the petitioner be maintained till the next stage. Subject. Huh?
One of the cell in the Arnicular 32. They are mentioned that it's a government land waiting.
No. We'll look into it, whether it is because why did you initiate action at the enhance of the Cotton University? It may be that the land he purchased long time back, but the government may have settled it.
Right.
Government have settled it. It is he who has to take action, not the government. That is the basic. In fact, this matter I've heard 3 or 4 times, and every time Mr. B. Sinha comes up and we keep on changing. Yeah. Yes, what is this? What has the state bank done to you?
Lordship, presently I have been working as a community health officer, Lordship, in Amtola, Lordship, under Telahi Moja in the district of Lakhimpur, Lordship. Prior to this, Lordship, I was
further amount without
I have
having
been working-
successful banking.
as community officer in the district of Kaplong Metro, Lordship. In the meantime, Lordship,
What is your account number?
my account number, your Lord. SBI account number 3847
After that, he will give you a copy. Yes.
3847 8672 648 Lordship. That is my SBI account number.
To insert the account number in the prayer. Why have you kept it blank?
Due to typographical mistake, Lordship.
Then
Forgive me. Please pardon. The complaint case is that Lordship that I did not repay the entire amount Lordship and known amount not repaid to the bank authority Lordship as agreed Lordship. Complaint case has been filed against me Lordship and I have duly participated Lordship, filed petition Lordship and Lordship. Presently Lordship, my total account has been held up Lordship. No way allow me to make transaction Lordship. Even my entire monthly salary has been credited into such account Lordship. Last 4-5 months Lordship, I was not allowed to make any single transaction Lordship.
now how much are they using it? How much are they deducting?
Lordship, they have entire amount Lordship in initial stage Lordship they have deducted, but subsequent. Not allowed.
Oh, you, what is your prayer? See, direction not to deduct further more amount from his salary account and immediately release which was held by the
Yes,
respondent.
last 2 months Lordship, entire amount has been deducted.
Where is your statement?
Yes, Lordship, that is why I am.
Where is your statement? The
That
entire
is
amount has
not
been.
not furnished to me Lordship. I have filed it.
Where is your statement in your petition?
Oh, yes, Lordship.
Yeah.
Annexer B Lordship, page number 22 Lordship.
Petition statement that the entire amount has been withheld. Issue notice. Issue notice. Where is your account?
Lordship, presently account in Lordship in Kamrup Lordship,
Where is your account? Which branch?
Lordship SBI branch. SBI.
SBI has
Panjabai branch. Panjabai branch.
branch.
Yes.
Issue notice making it returnable by 30/10/2024. The petitioner is directed to effect service upon the respondent number 1, 2, and 3 by way of registered as well as directed to take steps for effecting service upon the respondent numbers 1, 2, and 3. And why you're making the mission director National Health Mission a party?
Yes, Lordship. I have made party respondent Lordship. Respondent fee. Lordship, under their guidance, Lordship, I have been working Lordship, but my entire transaction has been held up Lordship. I cannot maybe Lordship.
Are this director, mission director not paying you? They are paying you.
Yes, Lordship.
So
They are
when
paying-
they are already paying the amount to so and so to
Yes.
the account,
Yes.
it is only the SBI not allowing you
But
to.
yes, that is why Lordship, that presently I am working under their guidance. I have a duty bound towards the departmental authority. But if the bank authority has whimsically and arbitrarily held up my entire transaction Lordship, but how can I dedicated my service towards the departmental authority Lordship? That is my responsibility.
All
to
things are
inform.
understood, but why are you making the department a party? Their department has not done any wrong
Only
with you.
for the kind information Lordship.
Kind
I have
information of
Yes,
them.
Lordship.
Okay.
But in any point of time,
You are
Lordship,
there.
I will be
For that department.
fetching departmental
Issue
proceedings.
is making it returnable by 30/10/2024. Pusto. Ms. So-and-so appears on behalf of the respondent number 3 and accepts notice. The petitioner is directed to serve an extra copy of the petition during the course of the day. As regards the respondent number 1 and 2, the petitioner is directed to take steps by way of registered as well as usual. In addition to that, the petitioner is also given the liberty to take steps upon the respondent number 2 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. Court लिखित रूप में तो अपना take steps within were registered and usual within 3 days. The case of the petitioner herein is that the petitioner has a savings bank account bearing number 384-786-72648 maintained in the State Bank of India, Panjabari branch. The petitioner had taken a loan from the State Bank of India
Initially, just hold on.
posted. On account of non-payment on account of the alleged non-payment of the loan amount, criminal case have been filed by the State Bank of India before the competent court, being CR case number 7746/2022. However, it is the case of the petitioner that the respondent authority, the respondent State Bank, have been unilaterally withholding to his have unilaterally frozen the account of the petitioner. And as such, the petitioner is facing tremendous difficulties in his day-to-day life. The learned counsel appearing on behalf of the petitioner seeks for an interim relief pending notice. In the opinion of this court, that without hearing the respondent, more particularly the respondent number 2, it would not be proper to grant any interim relief. According this court, directs the respondent number 1 and 2 to bring on record their stand by filing their affidavit on or before the next date. The interim order shall be considered on the next date.
Deep blood pressure.
Item 5.
Mr. Das,
Yes, sir.
have you informed your clients?
Lordship, actually, what I remember in the repetition, Lordship, one of the prayer was Lordship to dispose of the representation. And accordingly,
Understood, but did you inform your clients that on you are to dispose of it within 3 months?
perhaps it was not, perhaps it was not informed, your Lordship. I will check.
You have not informed,
Perhaps I.
and as such, now the contempt has come.
Lordship, if what I may propose your lordship, subject to outcome lordship. Give me 2 weeks time, lordship, let me inform them and get it, dispose of the representation.
This court, taking into account that the order was dated 6/3/2024 in WPC number 965/2024 was passed in presence of Mr. D.J. Das, the learned counsel for the respondent number 1 and 2 therein. Requested Mr. D.J. Das, and I inquired with Mr. D.J. Das, the learned counsel, as to whether due information of the order dated 6/3/2024 was informed of the order dated was passed on to the respondent number 1 and 2 of the petition. The learned counsel, Mr. D.J. Das, submitted that he may be granted 2 weeks' time to take instructions in that regard. This court directs the counsel for the petitioner to serve a copy of the contempt petition to Mr. D.J. Das, the learned standing counsel of the learned CGC. On the next day, this court fixes the matter again on 4th of November 2024. On the next date, Mr. D.J. Das, the learned counsel standing at CGC, shall apprise this court as to whether the order dated 6/3/2024 passed in WPC number 965/2024 have been complied with or not. The registry shall show the name of Mr. D.J. Das in the cause list.
Eleven. Let me go watch.
Yes. Too big a matter. Too many petitions.
Yo. Eviction matter from Gwalpara. Despite the order of this honorable court
Where?
in division bench as well as by your lordship,
Regarding?
without asserting the status of the land, they are issuing notice again, general notice for eviction. Question was whether this land, as the forest has issued the notice, forest department has issued. But till the other day, it was the revenue who was trying. In 2004, this honorable court directed that you make an inquiry, find out if this is open, otherwise you settle it. In 2004 itself, we are there for last 52 years. And lastly, your lordship's order, lordship may see, which has been clarified by the division bench appeal. Lordship will find it at page 262, Eleven. Okay. 26.
302.
Huh?
Appeal order, 302.
Appeal order play Pisha Bhai. Order
290 to 11.
Lordship's order 299 is the last page, 298. 298 lordship will find.
So what happened?
Sorry.
What is Paikan? Yesterday also I saw some Paikan wickets.
Yeah.
Today was also one fixed.
Lordship has referred it to restaurant, they
All
mentioned it.
that one, yes, yes, yes.
They say if this is, they are not sure whether it is a reserve forest or proposed reserve forest. They are not sure. So, now, Lordship ultimately directed that Lordship is there, page 298, paragraph 3. This court taking into account that no rights can be created or accrued in reserve forest or proposed reserve forest is of the opinion that there is no illegality in the notice dated 6/12/2017. Be that as it may.
Now, what is your case, Mr. Mohanto? I have read it.
Yes. Now, my lord, Lordship also directed if you have applied, they should consider my case for
Individual application. But
individual.
that will only depend if it is outside the forest land.
And they have not done it.
Who?
The forest department or the revenue authority.
No, revenue, have you submitted applications?
Yes.
Very
was
well,
long
that
back
will,
it was
that will
submitted.
be looked into. But
It
the
was long
fact
back
is,
submitted.
no, Mr. Mohanto, the fact is as to whether the land falls within the Paikan Reserve Forest or not.
Yes.
So-
That's why the division bench also directed. Lordship will kindly see at page 303.
What else is required now?
My lord, therefore, it has been clarified that we hereby clarify that before taking any actions against the appellants or similarly situated persons pursuant to the notice dated 6/12/17 itself they should know. The forest authorities are required to ascertain that the land so occupied by the appellants or similarly situated person falls within the reserve forest or proposed reserve forest lands. And after ascertaining the same, the forest authorities can take any action against only those persons who have illegally occupied the RF or PRF. This is the direction. But the authority has not done anything, simply issued the notice. Again, kindly see. 305 money. Thus notice, vague notice by the uh, K05 lordship will first see by the range officer. It is hereby informed that general public who have encroached the forest land and the encroachers who have constructed houses over the forest land and cultivating forest land by way of encroachment are directed to vacate the forest land. Which forest land? Is it nothing? No mention about Paikan or anything else. So no specification, nothing. Area of land, nothing mentioned. Then lordship may kindly come to 307. Under notice by the Divisional Forest Office. Here he says, he is hereby informed the persons who have been residing in the Paikan Reserve Forest that in view of the order dated 5/9/2022 passed in suo motu BIL so by the Honorable Guwahati High Court and the power vested upon the Assam Forest Act 1891. An eviction drive.
But
will be-
Mr. Mohanto, there is already a direction of the division bench.
Division bench also says the same.
Understood. So there is already, that is the case of Paikan.
That is a Paikan.
The
Yeah,
division
yeah.
bench has already stated that. Now, after that, what remains? What does this court have to say? This court have stated once, division bench has stated another, and what else do this court need to say? Again, reiterate.
What is our position lordship may kindly appreciate.
Understood.
Despite
means
the direction,
They are to
they
follow.
are issuing notices.
No,
Lordship
they
may say,
are
no.
issuing notices only to those people who are within the reserve, Paikan Reserve Forest.
Well, but then they are hanging up those in our localities, threatening us. That's the difficulty. We are in Asudubi, revenue village. Revenue village list lordship is find in their website. Asudubi is one of the revenue villages. In their website, some website.
You are in that?
Asudubi village. This is downloaded from their website. Here, lordship will find
Which
total
one?
villages under Matia
We are
Revenue
concerned with which one? Matia Revenue Circle.
Circle. You can find the villages.
All
in
these
here.
people are there in where?
Asudubi.
Huh?
Asudubi,
They say, my
Number
lord,
one.
they are from this.
Asudubi.
yes, Asudubi number one.
Asudubi, everybody,
Yeah, all right. We are for Asudubi.
all 535 persons. Asudubi CT. What is CT?
City, the part one, the city, census town. Census town.
Census town.
Census town.
But you are Asudubi CT.
City. Census, they have made a census. And so the township will be extended to that area, maybe. That is why.
Huh?
Some people have already been allotted land in that area.
Allotted means first, that is the main problem. Revenue can't allot any land if it is in the reserve forest.
No, that is why. Oh, on
Any
record,
allotment does not create any right.
my lord, on record, they have shown that Asudubi city, Asudubi census town in this document is clearly it is the Asudubi town population census 2011-2024. The city means Asudubi census town. That is why you see, we are only in the Asudubi. I can't it is away from us. If they extend it, they will have to notify. Up to which place? There must be some specification. Lordship may kindly see.
What Mr. Monto, what order need I pass, need to pass?
My sole submission would be this honorable court stay those applications so far it relates to the picture in Asudubi. And authority can proceed as per the order of this honorable court in the division bench or in the PIL. There is no restriction on that. But without complying, that has been clarified again.
Compliance is already there by the division bench. Why should this court, they are expected to comply?
That is why.
Then
If we,
if
even if we
they,
come by
if
it,
they violate that,
Well,
Mr. Monto, if they violate that, wouldn't that be a case of contempt? If they violate the directions of the division bench, wouldn't that be a case of contempt?
that is what I wanted to submit. I may come on a complaint, I mean, the contempt petition.
But
This-
it will be a case of
this-
that already has been directed
Uh,
that you have to do so by making very clear categorical observations.
Technically,
But how do this court again entertain the same aspect and
Well,
pass the same order?
well,
It will be a reiteration of the my earlier order, which have been also stated by the division bench.
well, in view of the subsequent action of the authorities by issuing again notices despite the order.
Notice has to be issued. Notice has to be issued, but they have not stated about the Asudubi thing and they issued.
No, Asudubi has not been said.
Then why you are here? This is an information which is being given out here that anybody who is there in the Paikan Reserve Forest and dwelling houses, they should be removed. That's on 6/9/2024. Why on your own you think that you are not, you are a part of Paikan?
My lord, we are lordship's apprehension. One may think like, but why we are before this honorable court, that is why I submitted.
This is the
Had
third
it
round.
not been the case that the authorities going and hanging up those notices in my locality, in electricity poles, in the places, and they are saying that you must vacate, otherwise we will come one day. That is why the apprehension.
They know. You are aware of the directions of the
My lord,
division bench. So what is required to be done is whether it is Asudubi or any place. If it falls in Paikan Reserve Forest or Paikan proposed reserve forest, you can throw them out, irrespective of anything. But if it is a case which is falls in the revenue village here, and there is also a specific direction,
my lord.
so I have nothing to do with that. There are directions which have been passed by this court, and this has also been confirmed by the division bench. If at all any order is to be passed, is a order if you violate anything, merely putting a notice out there, they have categorically said, as of now, where is your cause of action? It is only said that we are only going to do in Paikan Reserve Forest. It is supposed that they would not do. But if it falls in here, there is a violation, there would be a different case. But what is there? There is already a direction being passed by the division bench. What remains, Mr. Monto? You can't hesitate, keep on, it is the same hesitation. You want, I can pass the same order against by the division bench. But is it necessary that you need two stamping authorities?
Therefore,
This
my
is a written
responsibility.
writ of apprehension.
Huh?
This is a written apprehension. No
It's
further
not a
steps.
written apprehension. There is a some problem maybe.
Against-
My lord, earlier notices,
He's saying is what?
I got kun call for night.
my lord, had it been so, probably we would not have been able to be there for last 52 years. And you see, this honorable court once directed in 2004 itself that you verify and do all these things. Or subtly, 2005. That,
And did you submit your applications for settlement?
that time even repeatedly. Now they say when you have, as per your lordship's order, when we have gone there submitted, they say now, no, they say now that you come for this equality. Mission Vasundhara.
Yes.
Yes, Mission Vasundhara.
You
Now,
applied.
now this has been started from today only. Today, as per the news I have found, they are opening up now. So whenever they will open up, you apply to them.
Yes, yeah. Whenever they do that, it is presupposed they will do it, and if they don't do it, contempt.
Lordship will see prima facie, the subsequent notices were issued. Subsequent notices were issued without complying with the order of this honorable court.
No.
This
There is nothing out
this-
there. And in
this
fact,
line-
you see, kindly see, you are agitating this page 307,
Yes.
isn't it? 307 is of 6/9/2024.
Yes.
And the division bench has categorically mentioned on 24/9/2024.
Yes,
Then
that
what
was-
remains?
that was also submitted to them.
Then after that,
They
also,
have not
when the division bench has mentioned it, what else remains? What is your new fresh cause of action?
Lord, that order relates to
Mr. Again, you go to
Therefore-
division bench, but this time I'm dismissing it
No,
with
my lord,
cost.
no, my lord,
No.
Lordship will kindly consider one.
No, Mr. Mohanto, I'm dismissing
Kindly,
it with
kindly
cost.
consider
Sorry,
one
sorry.
aspect, my lord.
This
A
is
person-
an abusive litigation.
No, my lord, Lordship will kindly.
Mr. Mohanto, this is an abusive litigation.
Not at all.
If you have, yes, absolutely.
I will respectfully submit, my lord. Lordship will kindly bear with me. Persons come
Can't
to this
happen.
honorable court.
No, when there is a division bench order, Mr. Mohanto, when there is a division bench order out there, when it categorically stated on 24/9/2024, it is believed that they are going to do it. And this order was passed after the notice which was issued on 6/9/2024. And therefore, to again approach this court asking for the same relief does not arise.
My lord, no. Why? Circumstance Lordship will kindly consider. The order which was passed by the division bench for your Lordship, first, that was pertaining to a notice in 2017. This has
Then
come
also
now.
there was a direction.
Now this has come now. And nonetheless,
Nothing.
when the division bench order, which was passed in the case which was submitted by some of the petitioners, appellants, that was placed, they have said they are helpless. Therefore, only we have to come to seek protection, my lord. Because this is question of our human heart. That is why we are worried, my lord. They actually will be hanging upon our head all the time. They will go and threaten us. Lordship will pass an observation this time so that we can come on contempt if they do not do it this time.
Absolutely no.
Despite the order of this honorable court, they are issuing notice without specifying.
There is no
Separate
order of
categorical-
this court about issuance of any notice. My order was passed on 2/2/2024. The appeal was filed thereafter. Appeal order was passed on
24/9.
24/9 and they categorically observed this.
True. Well, that is why I pointed out.
Mr.
That order
Mohanta,
has been
you'll get
clarified.
the order immediately now. If you want to file an appeal, immediately go to the division bench and mention it.
My lord,
But I am going to pass the order in your presence here.
Lord,
No, Mr.
I will welcome it, but
No,
then
Mr. Monto, sorry.
Lordship will kindly consider this aspect.
Oh, Mr. Monto,
That-
I have heard you, I have considered you, now take my order.
My lord, please, please,
I would not delay it. By 1 o'clock, you
My
get a
lord.
signed order,
my lord,
certified
my
copy.
lord,
You
I
get the
know, I
certified
know,
copy of
my
this
lord,
one.
I know
No,
this is from.
when the division bench has categorically stated, it is believed that they are going to do it. And if they don't do it, then it is a case of contempt before the division bench, because the division bench makes it absolutely clear
True,
that
is
you
my
are to
case.
do it.
That
But
is
you
my
are
case.
not going to ask again a reiteration what the division bench have asked for.
My lord, I am not asking for iteration because that is final. Lordship once said that is all. But what now Lordship should say in my response submission, that despite all this, you could not have proceeded like this.
Why should I say that? Have they stated anything out there that it is not, we are going to do it in a revenue village? No. There are notices of categorically says to that effect that it is in only in Pican Reserve Forest it will do.
My lord,
Division bench categorically says. Mr. Mohanto, I think you'll get the order by 1 o'clock. Yeah. Heard Mr. K.M. Mohanto? No, Mr. Sorry.
kindly mention
No.
that the
I
first
will pass
notice.
the order in your presence, Mr.
My lord,
Mohanto.
if I can,
If you are not satisfied, you go before the.
no, my lord, I know.
No, Mr.
that
Mohanto, enough.
Lordship will pass an order without prejudice to anybody. I know that.
I am not going
I
to
know that.
say anything to that effect. Kindly
lord,
listen to this.
Yes,
order.
kindly say that this Pican is Pican there. We are not.
They can very well go ahead in Pican Reserve Forest. I
Yes.
even would not have passed that, but the division bench made my hands tight now to say that it is also in Pican proposed reserve forest. My case was specifically, I only mentioned about reserve forest because the notification is a very relevant notification. Once the final notification comes, then there cannot be any right or anything. A
True.
proposed reserve forest is a consideration when initial notification is made and till the final it is given.
Given.
In the meantime, it remains as it is.
That's it.
And certain rights may be there, but there cannot be any creation of new rights
Exactly.
once the notification have issued.
I only.
But in the instant case where the super division bench have also said about PF proposed reserve forest as well as reserve forest, my hands are tied. So under such circumstances, either you have two options: take my judgment immediately, or withdraw and file a contempt. Whatever, which one do you?
Very much. Very much. Okay. Contempt file. Let them come on contempt file. That's all.
Division bench, you have to file the contempt, not
Oh,
here.
yes.
Mr. K.K. Mohanto, the learned senior counsel, submits that taking into account that the order submits that taking into account that the order that the issuance of the notice dated 6/9/2024 apparently is in violation to the order dated 24/9/2024 in
It appeal. Appeal number.
writ appeal number 333/2024. Good stuff. Yeah. The learned counsel, the learned senior counsel submits that the petitioner would be well advised to approach the division bench for in the contempt jurisdiction. Taking into account the above and this court without expressing any opinion closes the instant petition, thereby it closes the instant petition. The petitioner's hearing would be at liberty to approach the appropriate approach, would be at liberty to approach the division bench if so, if permissible under law.
Lordship may kindly see that the Lordship demand comes opposed notice was issued to me on 11/4/2022, which is at page 92 of the petition, Lordship. The demand comes opposed notice is 11/4/2022, Lordship. This pertains to the assessment year 2016-17. And Lordship, the final adjudication order has been passed Lordship, on 24/4/2024, which is at page 115 of my writ petition, Lordship. 24/4/2024, this is relating to 2016-17. Lordship, in the final adjudication order, the assessing authority have mainly mentioned that why they have invoked the extended period of limitation. Normally, Lordship, the supposed notice ought to have been issued within the period of 30 months from the last date of Lordship filing my returns. They have issued the notice, issued my supposed notice beyond the period of 30 months within the extended period of limitation. So, Lordship, at page 118, they have explained what is the Lordship, why they have invoked the extended period of limitation. Lordship, they have mentioned that I have not filed the returns as well as my liability to pay service tax I have not complied with. Thereafter, Lordship, they have passed the order of assessment without mentioning why they have passed this order after a period of one year from the date which has been prescribed. Lordship, on the merit front also, Lordship, anyhow, I am exempted from payment of Lordship service tax because I'm a works contractor. But Lordship, in this case, Lordship, I am basically challenging the levy of service tax on me. Lordship, I may be permitted to place the Finance Act 1994. Lordship, Finance Act 19. Section 73 prescribes the time limit for Lordship issuing of notice as well as the passing of the adjudication order. Lordship, may kindly see page 16. Page 73 starts from page 16, Lordship. 73(1) says, Lordship, page 16, where any service tax has not been levied or paid as or has been short levied or short paid or erroneously refunded, Central Excise Officer may within 30 months from the relevant date serve notice on the person chargeable with the service tax which has not been levied or paid or short levied or short paid or the person to whom such refund has been erroneously been made. But if this 30 months can be extended to 5 years by way of a proviso, the proviso says that if in case of where the service tax has not been levied or paid or has been short levied or short paid by reason of Lordship fraud, collusion, willful misstatement, suppression of facts or contravention of the any provisions of this chapter for with an intent to evade payment of service tax, but if the 30 months may be substituted by 5 years. Lordship, even though I don't fulfill the any of the 5 criteria mentioned in the Lordship Soko's notice for extension of the period of limitation, Lordship, as prescribed in the Lordship Master
Date.
Lordship,
Date would be what?
relevant date Lordship is defined. Relevant date is Lordship defined. Lordship at subsection subclause 6. For the purpose of this section, relevant date means in the case of taxable service in respect of which service tax has not been paid, levied or paid, or has been short levied or short paid, where under the rules made under this chapter, a periodical return showing particulars of service tax paid during the period to which the said return relates is to be filed by an SSE, date on which such return is so filed. Where no periodical return is supposed filed, the last date on which such return is to be filed under the said rules. And in any other case, the date on which service tax is to be paid under this chapter or rules made thereunder.
So as per the rules, when it will be paid?
Lordship, the due date of filing of the return for Lordship for any year is Lordship 2 months. 2 months from the end of the assessment years. 2 months from the end of the assessment
So
year.
2016-17, it would
March.
be end of the assessment year would be when?
31st of May of that year 2017. 31st of May 2017. March
Here it was issued within 5 years, the notice.
within 5 years.
So this
That
is
is-
within time.
That is within time.
Then-
Lordship. Lordship, thereafter, Lordship may kindly see subsection 4B, which says the Central Excise Officer shall, Lordship, shall determine the amount of service tax due under subsection 2 within 6 months from the date of the notice, where it is possible to do so in respect of cases falling under subsection 1. If it, Lordship, falls under subsection 1, where Lordship, this 6 months, 30 months period is prescribed. Within 1 year from the date of notice, where it is possible to do so in respect of cases falling under the proviso to subsection 1. or to provide or proviso to subsection 4A. So Lordship, proviso will come into picture when there is a case of fraud, willful misstatement. Lordship, my first submission is that my case is not relating to fraud, willful misstatement. They could not establish it.
Now, if
So-
it is a case of, if it is a case that whether it will fall or not,
That will not,
well, education.
whether or not it will follow or not, Lordship, whether it will fall or not, 1 year has lapsed, Lordship. My order was passed in 2 years, Lordship.
But why not an appeal?
Lordship, appeal,
Because the word is where it is possible to do so.
Lordship, possible to do so, Lordship, it is preceded by shall. Lordship, the Central Excise Officer shall determine the amount. Lordship, the Bombay High Court as well as Delhi High Court has specifically dealt with this issue. Where, what is the meaning of where it is possible to do so? Lordship, may kindly be allowed, allow me to paste the judgment of IDFC. First Bank Limited versus Union of India, the Bombay High Court judgment. Paragraph Lordship 13, Lordship, the section 73B is Lordship quoted. Paragraph 13, Lordship, page 8. And thereafter, Lordship, paragraph 40 is a submission of the respondent authorities in this respect. That 73(4)B does not make it mandatory to decide the case in 1 year, and a notice can very well be decided beyond 1 year of its issuance. In facts of the case, even referring to provisions of section 74(B), which are brought in the stated book by an amendment made to finance so and so, such contention as convinced by the deponent of the reply affidavit. Lordship, this was the reply affidavit that they had filed, that it can be made beyond a period of 1 year because it does not say where it is possible to say so. To do so. Lordship, paragraph 18 of the judgment deals specifically with this issue.
But in this case, why did you submit your reply on 17/11/2023 after 1 year? And if you don't submit your reply next morning, you are going to come up out here and look here. This is the case. It has to be taken. It is not possible. You duly submitted your issued you the notice. Why did you take almost 1 year, more than 1 year to submit the reply on 17/11/2023?
I was not expecting it, Lordship. So
No, then very
In the-
well go and file an appeal.
in the preliminary round,
Bench following the Supreme Court judgment also, wherein it says that an appeal, if an appeal lies against an order, you should file an appeal. Why should this court entertain this type of request?
question of law.
Question of whether, because whether there is a justifiable reason or not. Justifiable reason is whether it is there or not. This is another aspect of the matter which will be looked into. You see, in the earlier case, there was a long delay even for these 5 years.
Yes, Your Lordship, 4 years.
It's not there. In this case, it is within time. The notice was issued. Here is the case where you submitted your reply on 17/11/2023 after 1 year. Why did you submit after 1 year? And then where didn't you by yourself waive this section 4B by
Okay.
submitting after the period of 1 year?
Lordship, this issue has also been dealt by IDFC, but Lordship, still I would like to say that Lordship, this 17/11/23 reply was given to the respondent authorities only, Lordship, after we had we failed to satisfy the respondent authorities that we are not liable to be registered under the act because we are.
That is a question of fact.
Lordship.
Because this is the document which is there out here that you have submitted a reply.
But even
You
after,
submitted the reply on 17/11.
Lordship, thereafter
Then-
also they took another 6 months to pass the order of adjudication, Lordship.
Right, it is within time.
Lordship, Lordship, they cannot bypass the Lordship statutory provision which has said sell. Lordship, which
The Bombay High Court has also stated that there would be there can be a justifiable explanation. An explanation, a reasonable explanation may happen. But yes, I would have understood in the instant case that if initially there was a delay, then the question would be different. In the case, no delay.
they have invoked the extended period of limitation, but the extended period of limitation cannot be invoked in this case because there is no
Fact, whether there is
Yes,
a
Your
question of fraud or not.
Yes,
That is the case which will be very well taken up by the statutory authority. It's not a question of law.
adjudication order which has to be passed, within a period of 1 year from the date of Lordship issuance of so cause notice. As far as possible, Lordship, Lordship, what is the meaning of as far as possible is, Lordship, in case if they can show that in any case it was not possible at all to pass any, like Lordship, force measure. Lordship,
Submitted your reply on 17/11, meaning thereby that on 17/11 you have acquised yourself and submitted, look here, with the even after a period of 1 year, I am submitting. Why did you submit on 17/11? You shouldn't have submitted. No, dismiss.
but Lordship, Lordship may kindly appreciate, Lordship, this is not a case of dismissal, Lordship, this is a very clear case, Lordship, may kindly see that 1 year has been present.
But in
Lordship may kindly see that, Lordship, it was not a COVID period at that point of time. They could have, Lordship, very well, that was not a COVID period, that it was, they were prevented from reasonable cause.
there's no COVID business here. There's no COVID business here.
Lordship, during the period of COVID, Lordship, if they can say that,
11/4/2022, there is no COVID.
that is what, Lordship,
So as
Lordship-
on that date, on 11/4/2005, 11/4/2022, you were issued a notice.
yes, Your Lordship, so cause notice.
You received the notice.
Yes, Your
Within 1 year, he did not. You thereafter you should have say, come up, don't say anything. That 1 year he has not done it. Matter over. Let him pass an order and come back. But here, what do? You go and submit a reply after 1 year and look here, this is my justification. Thereby, are you not acquisitioning yourself out here? That look here, okay, whatever it may be, forget about this 1 year. We are still submitting to your kind jurisdiction.
reply, Lordship, only to the effect that I am not a registered dealer as well as I have.
Say on 17/11, I would have understood. You did not submit, or you had submitted earlier. In 2023, you could have very well submitted on 10/4/2023. And say, though, after 1 year it's over. Yes, he can't pass an order if we go by this. But here you yourself have given them the justification. Then look here, how can I do it? I can't do it because of the fact that they submitted on 17/11. They were given various hearings. This is how it is.
Thereafter also, Lordship, they took maximum time of, Lordship, 6 months to
Ah.
pass. After that also, they took again 6 months time to
So
pass the
6
adjudication
months
order,
is
Lordship.
permissible as far as possible.
But as far as possible, Lordship, before that there is a cell. They have to pass that order within.
Shell has to be read in the context as far as possible. Even the Bombay High Court was kind enough and then also said that shell will mean shell, but then also there will be a case of reasonable or justifiable explanation. Here the explanation is on the face of it. You submitted on 17/11.
Lordship, 17/11, Lordship.
You
are
better
going
do
by-
one thing. Have it after which. There'll be a much kinder judge.
After vacation, Lordship. Better be kindly be taken off after vacation.
Eh?
Better be kindly be taken off after vacation.
Place the matter immediately on 21. Because I may again come back on 2.
Lordship, 29th, Lordship, 29th.
Okay, then you are Then if that judge doesn't take it, it will again fall back into my hands. Then don't tell me.
Chief, I'll take this.
No, it is a case of dismissal. Leaves the matter at the request of the Learned Council
After
for the
vacation.
petitioner on 20,
Nine.
on 30, not 29, 30,
30.
10/2020.
Much obliged, Your Lordship.
It will be again helpful to give it to the.
Much-
Five RBI, filing the activity.
Why you have not filed? What is wrong with the RBI? Why they have not, so much of time is required to be given?
Today morning I have.
The affidavit. Show me.
Fine.
You've given him a copy.
Just informed that I.
Yes, CID. Okay. We have this matter again on 5th of November when I'll be there. And we'll see the face of that senior superintendent of police. Along with the case there. What happened to the division bench?
Has not been listed.
What happens, Mr. Manan, there is a one problem out there. I can't dispose of this matter if the division bench does not take up on, because once he has stayed there, direction. What direction can I pass
What?
there?
My-
Except for continuing with this investigation.
My issue actually was happened, this person's wife is unwell and he has to take her to Delhi. So the communication is not there, so I could not appear in the without the authority. That's the issue. So I think he will be returning very soon. The next date I might be able.
No, that is the problem.
Yes,
If
I
you
understand.
don't appear, if nothing is done in the division bench, if the division bench holds it, that it is not possible, that it is not there.
Yes.
Then it
I've-
is a matter for there. Another aspect is there, because now the trial is already taking up the issue
Yes.
against the petition, against the respondent number 8.
Mm.
As against the other aspect as regards you getting the money out there, although this court has passed, that portion has been stayed. So this court can't pass that order any
Yes.
further.
That is
So that is one. Two. Here is the senior superintendent of police who is the least bothered for whatever good reasons. Is not bothered.
I'll try to appear as early as possible because he will be back within a
problem.
week or so.
When we see the senior superintendent of police before this court on the next date. And you are taking action. Before that authority.
One, because of this proceeding, Airtel has themselves, I think from day for yesterday, it started notice. Like a true caller, it automatically comes in the Airtel phone itself. That this is a suspicion, it will come like a spam. They have started day for yesterday.
Very good.
They have started, that's why they inform.
No, that is good. No,
They
but
have
whatever
started
may
their
be,
own-
you see the problem which is there, a small problem, it is now going bigger and bigger for you also. Because otherwise, a case of an 11 lakh, which is now going beyond proportions.
State, otherwise your lordship can take up. the
But how
matter.
do I take it? How do I finally adjudicate? Can I pass an order to that effect, finally adjudicate and keep it out there when he is only taking the division bench is only taking an interim order?
That part has been stayed only, paragraph 26 or 26 have been stayed.
I will pass an order to that effect that this court can't proceed with the adjudication in view of the division bench order. Let him be shown it before the division bench. I hope then the division bench may consider.
And
The further proceedings I
one-
can't go ahead
one
because
more-
of that. Otherwise too, they are already taking it, the issue. Your liability, what I wanted to only bring it is that the state bank out there's liability which was there. Initially, my direction was so that the state bank pays it to him. The inter-se liability as to whether the state bank will be entitled or not, how much would be, that will be very well based later on decided, taking into account that the petitioner was a pensioner. But the fact that the state bank has moved the division bench and the division bench has passed an order to that effect, it now becomes very difficult. It was only an intercept thing as to how whether you can be made bound to pay to the state bank the amount because of your that was the so that it was limited to only this 11 lakhs issue, nothing more than that. But the fact now it has become it is going bigger and bigger, and thereby Airtel will be in bigger problem. The state government would be the senior superintendent of whoever it is would also be in a bigger problem. And the state bank also may invite certain observations at a later stage. Yes, but the question is this. How the RBI deals with another aspect of the matter. This court may also pass, if the RBI says anything else, this court may also pass orders to that effect. That this is not in consonance with that. But these are all the other aspects. But all these things cannot be further proceeded unless the division makes sense.
There was a order passed, NDRC, I think, recently, but last week, NDCRC or something like that, who has passed an order in a case where there was a defrauding of 67 lakhs of a retired person. The order was of 90 lakhs. I couldn't get the order. I have got just the news clip. I'll try to get that order. That was passed against the SB.
I have also passed one order against the SBI. The SBI has appealed and that appeal got dismissed. That is a case against Justice B.D. Agarwal's judge case. He also lost around 6 or 10 lakhs out there due to some fraud. But the fact that he immediately informed, and the other thing is, there was an RTI information sought wherein the SBI had categorically mentioned that we have frozen that account. And as such, the amount did not pass. So he said that. So under such circumstances, and I think the matter went to the division bench upheld this judgment. So there the matter ended there. But here is the case where whether the SBI or not, here is the case where this person could not have got. There was nothing out there as regards he could have got anything from the facts.
Because here it's a seam swapping problem has created
Understand,
the
the
whole.
seam swapping thing is understood, but this is therefore it is a case where the petitioner had no hand. It was beyond his control. Yes, the fault may have been of the act which led to. I don't say that the state bank is otherwise responsible, there was any negligence, but the state bank could not have done it anything. There was no negligence on, and I think my order is also reflected
Yes,
in that. So the
exactly.
state bank had no negligence. The negligence was on the part of the Airtel and the culpability of those other persons who had led. The Airtel as well as the SBI and you, both of you have been different. So therefore, the question would have been, could Airtel be imposed with certain amount so that the SBI could have been very well settled, the liability of the SBI could have been settled. But that could not have been possible on that day, taking into account that Mr. Das has raised various other issues, that he wanted all these various other aspects. There is some IAs being filed there. So that is another aspect. Now, because of that disorder, I think TRI is now taking up the action against them and say that there can be a liability of an amount of 50 crores.
Maximum.
That is enough. But then also the issue which was 11 lakhs has now become very big because of that. And this is an issue of very vital importance, taking into account that every time everybody is getting something needs to be done.
Now every alternative there's something on the other head.
Third, the learned counsels appearing on behalf of the parties. Mr. S. Sharma, you are Mr. P. Hazarika, the learned counsel for the RBI, submits that he has received the instructions and would file the affidavit during the course of the day. This court accordingly, at this stage, this court finds it very pertinent to observe that the further continuation of the instant proceedings, observe that it would be difficult on the part of this court to further proceed with the instant proceeding unless there is a decision passed by the division bench in writ appeal number 204/2024. The counsel appearing on behalf of the petition, as well as the counsel appearing on behalf of the State Bank of India, submits that they would take appropriate steps in that regard. It is further seen that this court had time and again asked the Senior Superintendent of Police, CID Cybercrime, to submit a status quo report as regards the Rongya Police Station case number 944/2020. However, neither on 6/9/2024 as well as today, any such status report has been placed. The action of the Senior Superintendent of Police, CID, of not submitting the status report in spite of specific orders being passed touches on the majesty of this court. It apparently appears that the said official is not adhering to the specific directions passed by this court from time to time. Under such circumstances, this court fixes this matter on 5th of November 2024, on which date the Senior Superintendent of Police, CID, Cybercrime, shall be present at 10:30 a.m. along with the status report in respect to Rongya PS case number 944/2020. In addition to that, the said official shall also file an affidavit explaining as to why, in spite of specific orders being passed, the status report so directed earlier have not been placed before the court. Madam, how do I further proceed with the instant proceedings? You are his junior? Okay. How do I further proceed with the instant proceedings unless you make the proper department a party? Mr. Ardor is going to make that submission that I don't appear anybody for this WPT BC department is no longer in existence. How do I pass any order in your favor? Then this aspect was specifically brought in. Yes, Mr. Dhar, what is this case about?
The thing is that they are claiming that they should be under 226, that the honorable court should pass a mandamus, that they should be given this ST certificates, STP certificates. That is their, my lord, contention. That is what I understood, my lord. And Deputy Commissioner, Chitragar, and Tribal Affairs.
Using the year to all eligible members of the Ravi community as STP. It's the Ravi community is there in that scheduled caste order.
That is not there.
So he wants that this court should be the parliament.
The presidential order, my lord, and 40 that is to be there. And furthermore, my lord, I don't understand. This is not a PIL. For the whole of community, one person coming,
Whatever may be, how can this court issue that direction?
Get password for today.
It's a very interesting aspect. You see, these 341 and 342 no? Was earlier 300 and 301 when the constitution was drafted. There, this is the chairman, Dr. B.R. Ambedkar saying that the second part of the second clause of Article 342 or second clause of Article 341 was specifically brought in so that nobody except the parliament can do so. And you want this court to be the parliament without there being this court fighting the elections. Isn't it? When? That is why Mr. Purkasto is nowhere to be seen. When?
Say he absent for 2 days.
Huh? When does he want it? After vacation, before a kinder judge. Chalo, list this matter on 23rd of October. Again, if it comes back to me, dismissed.
presidential order.
Yes, where is he? Mr. C. Goswami, P. N. Sharma, where is it? What is this matter about? Hello. Plan appears on behalf of the petitioner on call. What is he asking for? None appears on behalf of the petitioner on call. Mr. D. Chaudhary, the learned counsel appears on behalf of the private respondents. And Mr. You are appearing for? BTC? What does BTC have to do? Appears on behalf of the respondent number 8. And so appears, taking into account that the petitioner have not represented. Seems that the petitioner have lost interest in the instant proceedings for which the petition stands dismissed for non-prosecutions. Interim orders, if any, stands vacated. 15.
My lord, I have been instructed to withdraw this petition.
Mr. K. Sinha, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant petition. Accordingly, the petition stands closed on withdrawal. Interim orders, if any, stands vacated. Yes, what is this?
I've paid 2 weeks time.
Two stalwarts appearing must be very heavy matter.
My lord, very uncommon nature, my lord, very
Huh?
uncommon type.
No,
Without writing a
yes.
judgment, my lord, pronounce death, my lord, judgment will be delivered.
What?
Page 26, your lordship can.
Setting aside and quashing the contained in email issued by the register of vigilance, setting aside and quashing the de novo proceedings in PR case number in R. distribution was this. Looking is like in washing. How do they do it now? So you are asking for setting, what is this 22/3/2016 order?
Your lordship kindly page 26 first now.
Huh?
Page 26.
Eh?
6, madam.
It's six. Accused Devojit Fukon is present today, heard arguments forwarded by the learned advocates from both sides considered same. Later on, judgment pronounced in order written in open sheet. Kept in with this year after due consideration of the event. Not been fully finished. Now then,
My lord, practically there is no judgment. In such type, about 45 cases, my lord, about the same judgment, says my lord, same judicial officer. And then your lordship kindly now, my lord,
who has done this?
so now, my lord, your lordship kindly page 36.
Who is that person?
The chief justice magistrate from.
Sangeeta Gogoi Bora.
No, this.
Huh?
Your lordship kindly page 36 kindly. And I am reading it here. Page 36, 36. The dinner going query. No, not that query, hearing.
Yes. Person can directly be informed that they arranged for dinner will be. Then,
Okay, now there's he's been selling. After that, my lord, Leonard Pal does, my lord, issue summons to him, my lord. Page 28. He came before this honorable court.
Page?
28. After that short order passed by the magistrate for CGM, then someone is been issued after 1 year. Then I came to know.
the attendance is necessary to answer the time. Then,
This is the 35. And the district judge wrote to the CGM Tinsukia. On the basis of the order passed by the High Court, vigilance, which registered vigilance.
yes, what is this?
This is in terms of that order passed by the registered vigilance, my lord.
Now, here is your case that look here that I have been already exonerated in this criminal offense, and as such, I cannot be again prosecuted in terms with section article 22 or 20.
20, bracket.
That is your case. But the fact remains that if you are to be exonerated, you have to be exonerated as per law. And if it is, then obviously you will get it. Now, have you been done exonerated as per law?
Now, my lord, that's true. Now the dinner inquiry from which stage, my lord? There's the, from which stage hearing?
Huh? Which stage
Dino
is the
was hearing.
stage at which it was?
Hearing on, my lord, everything is completed. My lord, your lordship kindly see.
No, it can't be a dino. It will be from the stage at which it is. Where's the file?
It record has come, my Record lord. has come, Record has my come lord, to it was the order. But in such situation, my lord, there's a division bench judgment and taken Seomatom passed out and taken the judgment passed by our High Court. My lord.
Do they say?
No, when Alpinian judgment is not signed by the, my lord.
Whether registered vigilance can pass an order or it is the appellate authority.
Yeah, administrative order, madam, not judicial order.
If the judgment of the apex court says it is the appellate authority in rare cases.
But it is exam.
Oh, so 21/5/2015, 313 is done, which means the prosecution evidence, defense evidence, if any, or there being not there, 313 was done. So from there it will proceed.
My lord, I'm not saying that. I'm just submitting, my lord.
No, he is not
Whether, my lord, legally, whether registered vigilance can pass an administrative order, my lord. Because the apex court says, my lord, the appellate authority. Who can pass this order from that stage? That's the, from there I got no issue, but whether registered vigilance can pass.
Forget about that. Whether you are challenging the order, the process was reinitiated.
Yes.
Forget about the vigilance order. We'll take care of it. we say that it is okay, but it will shall only proceed. Without a judgment, it cannot be.
Cannot.
Where is the judgment? Where is the provision of the CRPC?
That is,
What does the
that
division
might
bench
not even, judgment was not been written, my lord.
unless judgment is prepared and signed, mere oral pronouncement cannot be acted upon and Iman oral pronouncement without written judgment cannot be taken. So the law is very clear.
Very clear. Yes, that's right. No, it's all right. Because the summon is issued as if it will start at the beginning, that's the reason. If it
No,
starts,
no, no.
yes,
It will only start at the
Exactly.
time for arguments.
exactly, my lord, exactly. I am,
Because three
yes,
months
sir,
is-
only, that's why, my lord. You know, go hearing. The lordship can see very. But
clear
page
and-
20
It's okay.
doesn't say so.
Whatever may be, we need not go into the question of the register doing all these things,
Fine.
because if we go into that question, it will affect many other proceedings. So we need not go into that. We will only go into the question of this particular thing.
My lord, yes, absolutely, lordship, right, my lord. I accept that, my lord.
Yes.
Only I came because the 28 page number, someone issued as if the beginning it is start,
No.
you know, that's not the case,
No,
man.
it will be start only after.
Exactly,
the
after,
next-
it's basically, it's
After theta. Already theta didn't come. Complete.
it's argument only, my lord.
Only
It's argument,
argument.
that's
Only
all.
arguments.
Yes, 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 I accept that, my lord, yes.
So we'll pass the order now
Exactly, yes, ma'am.
in your presence.
Right.
I may get wrong if I take it back.
First case मैंने आ लिया मैंने क्या करना है case मैंने division में करना है क्या तो order court has taken so much in such type of cases that is a judgment in RAM not in 100%. All cases that is being
Large number of files. But for
75 cases.
75 cases, yes.
It's been dismissed.
Heard Mr. M. Not, the learned counsel, senior counsel assisted by Mr. D.P. Bora, hearing on behalf of the petition, and Mr. T.J. Mahunto, the learned senior counsel assisted by so appearing on behalf of the respondent number 2 and 3. So, yeah. Going to the appeals of the respondent. What do you have to say in this? Huh? That is okay, but what do you have to say? As regards this submission, the case. Let us not spoil the time. The petitioner herein have challenged the order, contained and dated 22/3/2016, issued by the Register Vigilance, Guwahati High Court, as well as have sought for quashing of the notice dated
My, the original, the date is not there, page 29, may I kindly peruse, my lord.
notice
30th April 16, last line.
dated, you said no date is there. It is there in bold letters, 34/2016.
That is for appearance, to appear on that day,
Given under my hand and seal on the 30th day.
April 16, my lord, yes. Yes, yes, yes.
Dated
Yes, yes, yes.
34.
The last is right, my lord. Last is right. Yes.
In GR case number 2082/2013. Puस्तaka. The case of the petitioner in brief is that an FIR was lodged on 4/12/2013 against the petitioner, which was registered and numbered as Tinsukia PS case number 921/2013 under section 448/336/427/34 of the Indian Penal Code. Subsequent thereto, a GR case was registered, being GR case number 2082/2013 before the Court of the Chief Judicial Magistrate, wherein the trial commenced on submission of the charge sheet by number 2/14 dated 21/1/2014, wherein the petitioner was mentioned as the sole accused person. Thereupon, the charges were framed against the petitioner under sections 448/336/427 of the Indian Penal Code, read with section 3 of Prevention of Damage to Public Property Act 1984 by the learned Chief Judicial Magistrate Tinsukia. In the same case, at this stage, this court finds it relevant to take note of that the records of GR case number 2082/2013 was placed by Mr. T.J. Mohanton. You placed? Was called for by this court. A perusal of the said order sheet reveals that on 12/9/2014, charges were framed under section 448/336/336 and 427 of the Indian Penal Code, read with section 3 of the Prevention of Public Property of the Act. It further said that on 8/5/2015, two witnesses were examined, cross-examined, and thereupon discharged. And the court upon closing the evidence of the prosecution, fixed 21/5/2015 for examination of the accused under section 313 of the Code of Criminal Procedure 1973. On 21/5/2015, the petitioner, who was the accused, was examined under section 313 of the Code of Criminal Procedure of the code, and he declined to adduce defense evidence. And fixed 30/5/2015 for arguments. It is further seen from the records that on 30/5/2015, the learned Chief Judicial Magistrate Tinsukia passed the following order. At page 26 of the same, which is reproduced, extracted here and below. From a perusal of the above order, it is seen that the petitioner herein was exonerated of the charge and acquitted. It is also seen that a judgment would be pronounced in open court. It is also seen that order specifically refers to a judgment pronounced in open court, written in separate sheets, kept tagged with the case records. It is, however, relevant to take note of that an entire perusal of the case record reveals that there was no judgment. In separate sheets kept, which was tagged with the case reports. The record for the proceeding further, it is relevant to take note of that this trend, this type of Muslim, it is also relevant to take note of that the present is not only the case wherein the same Chief Judicial Magistrate Tinsukia was involved in exonerating, acquitting an accused person without passing a judgment. Preparation and passing a judgment. In the 22nd of March 2016, which have been challenged in the instant proceedings, also showed where 45 cases wherein the same chief judicial magistrate had committed such dereliction of his duty. At this stage, this court finds it relevant to take note of an order passed by the division bench of this court in WPC bracket taken up number 3954/2012, wherein the learned division bench of this court categorically held that unless judgment is prepared and signed, mere oral pronouncements cannot be acted upon, nor can an aggrieved party take remedy against such a judgment. The said order dated 24/8/2012 is reproduced hereunder. Egonde. In that view of the matter, as there is no judgment, yes, yes, help me. CPC, I would have otherwise say 3, 353 or 353, yes. This court have also taken note of section 353 of the code I've really taken note of section 353 and 354 of the code. Which stipulates as regards the judgment to be passed in every trial by any criminal court of original jurisdiction, as well as the language and the contents of the judgment. In section 354(1) of the code, it has been categorically mentioned that the judgment referred to in section 353 shall contain the point or points of determination, the decision thereon, and the reasons for the decision. It has also been specifically mentioned in clause D of section 354(1) that if it is be a judgment of acquittal, the judgment shall state the offense of which the accused is acquitted and direct that he shall be set at liberty. Under such circumstances, if this court duly takes note of the order dated 30/5/2015, by no stretch of imagination, the same can be considered to be a judgment falling within the ambit of section 353 and 354 of the code. It is further mentioned, relevant to mention, that the same order dated 35/2015 is based upon. And it is further relevant to mention that in the very order dated 35/2015, there is a specific reference to a written our judgment written in separate sheet and kept tagged with the CR, which is not there. This, in the opinion of this court, therefore, in the opinion of this court, the criminal proceedings which have the criminal proceedings being GR case number 2082/2013 cannot be said to have been culminated without there being a judgment. More so when the trial had commenced and statement of the accused person was taken under section 313 of the code. Under such circumstances, this code does not find any illegality in the order dated, in the notice dated 30/4/2016. Be that as it may, this court, however, observes that the petitioner, upon appearing before the concerned magistrate, the proceedings would be Where the provision similar to the CPC, whereby the proceedings thereupon will proceed as if from that date.
Six, there's one, 320, well, 26 old act, the new one is
No, no,
365.
no, this will be the old one, na? We cannot go by the new one now.
326. One magistrate.
No, no, no.
If one magistrate transferred, the other one comes, who will take up the matter that way?
Where? 3,
326.
26.
Yes.
Proceedings. Shall the proceedings of GR case number so and so shall continue in terms with section 326(1) of the code, meaning thereby that the present magistrate before whom the proceedings would continue, proceeding being GR case number so and so would continue, shall proceed post the statement of the accused person being taken under section 313 of the code.
The Nitin Bhai case.
Huh?
Nitin Bhai case, this part has been explained.
Am I right or wrong?
Absolutely right. Always, Rashid always right. So for judgment is concerned.
With the above observations, the instant petition stands disposed of. The petitioner hearing, there was a stay.
Record has come, no? But record has come here, so.
This court directs the registry to forthwith send the records to the court of the Chief Judicial Magistrate, Tinsukia. And the learned Chief Judicial Magistrate, Tinsukia, shall issue notice, summons to the petitioner and proceed as directed herein. And proceed from the stage as directed herein.
Again, it will go back to the first stage. That's very important. Oblige, my lord.
Why it has become infectious?
I have no idea about that. We last contacted the petitioners on 2022. At that time only they said that it was infectious. The matter was not listed.
The learned counsel appearing on behalf of the petitioner, so and so, submits that the instant repetition has become infectious. Taking into account the above, the instant repetition stands closed and infectious. Mr. DJ Das appears on behalf of the respondent number.
My name.
Immortals events, that's it.
19.
My lord, in this case, my lord, respondent number 4, my lord, Longki Terong, file a land dispute petition before the secretary to the Caribbean Autonomous Council, my lord. Stating earlier, inter alia that he has purchased a plot of land of DAG number, my lord, 402/2626, patta number 279 of village Shikari Pathar, Oza Longfar on 13/1/2012. But he could not take possession as the petitioner herein in possession, my lord. And he stated that the petitioner may be evicted from the suit land, from that plot of that land, my lord. I have filed an affidavit in
When?
My lord, in 2018, there is an order, my lord. There notice was served in 2018. Two 280. My lord, impugn order, my lord. Lojima court's order, my lord. My lord, impugn order has already been, my lord, reviewed, and new order has already been passed, my lord.
Where?
My lord, we have not bring it on record, my lord, in 22/5/2023, my lord.
Which
Yeah,
order is the impugn order?
Page 26, Annexure E. That is Annexure E, my lord. Direction to hand over the possession, my lord. So we have already modified that order, my lord. The cases become infructuous. And this is the order. Only now we have passed the order for demarcation, not to hand over the possession, my lord.
We dispose it of. See, here is a case where there was a direction. Your only worry is that there was a direction for issuance of possession, handing over the possession.
My lord, my case is that I am possessing the different plot of land. Tag number, patta number is different. But there is no connection with the plot of land pleaded by the respondent number 4, my lord. My plot is different. The learned secretary, my lord, without going through that, my lord, passed the impugned order, my lord, directing to vacate the land, my lord. This plot of land, my lord, my second paragraph in my synopsis, my lord, I have stated. The petitioner appeared before the respondent number 2 and contended that he has been possessing.
No. First of all, show me your sale deed.
My lord.
Sale deed.
No, my lord, I am a lessee, my lord.
Then why you are saying that you have purchased?
No, I am not purchased. Respondent number 4 purchased. Respondent number 4, Longki Terong.
No. Who has purchased the land?
Purchased, my lord, that my case is that Longki Terong purchased the land. He has filed an application.
I am asking you, who are you?
I am the lessee, my lord.
Lessee of whose land?
Under Jangfung Ronghang. Jangfung Ronghang is the owner.
Then?
My lord.
Then?
And I have taken lease from Jangfung Ronghang. Lease deed is there, my lord.
Where is the lease deed?
Lease deed page 15.
Page 15.
Page 15, my lord. I am Manik Chandra Shil, and my lord, first party is Jangfung Ronghang. He is the owner.
2.5 kathas situated at Shikari Pathar, so and so in the district of Karbi Anglong, white periodic patta number 3383 and dark number 209385. Now, here the land of this person concerned, Longki Terong, is dark number 402/626.
Yes.
A periodic patta number 279.
27.
And the lease was for 1990 years and 36,000 was taken, my lord, as the, my lord, premium.
Now, show me the title of that person who entered into a lessor. Show me his title.
My lord, that I have not.
Petition should be dismissed on that count. On what basis you are claiming you only on the basis of this lease deed?
My lord, since 1995,
So what?
I was a lessee, my lord,
So what?
under the lessor.
So you
Since
have been
1995, my
lessee
lord.
under the lessor in the year 2004.
With the Manik Singh, and before that, his father was a lessee under that person. My lord.
Huh?
I have stated that there.
No, unless you show that this person, Jongthong Rohang, has any business with this, has any title over any land. How does this deed of lease have any relevance?
My lord, this patta number is different. Restaurant number 4.
Anyways,
patta number is
they
different.
are going to go for a demarcation and find out as to whether 1 Katha 10 lechas which was purchased by so falls, are you in possession or not? As per them, you are in possession of that land.
That number 402.
To demarcate the land of 1 Katha 10 lechas covered by Dag number 406 and 426 of so and so immediately. So they will demarcate and then only show down the possession, and thereafter what actions are to be taken, they will take it. Mr. Bolwa's client will take it, isn't it? No, nothing remains. But your petition otherwise should be dismissed. If I have to enter much into the merits, I'll dismiss your petition. So let us go as on the ground that it has become interruptions.
My lord, impugned order, if your lordship.
Impugn order is no longer there, Mr. Day. Impugn order is no longer there. Impugn order has been already reviewed.
My lord, reviewed whether, my lord, my notice was given to the parties or not, my lord, that is also not.
The review is in your favor. Why do you need a notice? Okay, let us not consider this. We dismiss your petition on the other ground. We'll dismiss it on the other. Okay, heard Mr. P.C. Dave, the learned counsel appearing on behalf of the petitioner. Mr. We don't take into account this order. We say that there is nothing, no basis of, and dismiss the petition. Then, and direct them the area, we shall not take into account.
My case may be, my lord.
Your case,
decided
you
on
don't have
merit,
any
my
case. Mr. Counsel, you have no case. First of all, that person, how is these 90 years of lease done in this manner with a 10 rupees stamp paper?
That is the
What are these type
My
of
lord,
leases?
this is purely a dispute
What
between
purely?
two parties, my lord.
So what?
Between two parties.
So what?
Civil court is there, my lord.
No,
Therefore,
so
court
what?
should be decided.
You are in possession?
My lord, I am in possession that is the patta number 83. Tag number 209
First
oblique.
of all, whether that
235.
you have any right over that on the basis of these type of documents?
My lord,
Heard Mr. P.C. Day, the learned counsel appearing on behalf of the petitioner, and Mr.
1, 2, 3.
when I appeared before
In the-
the secretary, my lord, no copy was.
division bench, every LC division bench. Mr. Yeah, appears on behalf of the HUP, appears on behalf of
One, two,
respondent
three.
number 1, 2, and 3, and Mr. B. Burwa. B. Burwa appears for the respondent number 4. The petitioner herein have challenged an order dated 9/9/2016 passed by the Joint Secretary, Department of Revenue, Karbi Anglong Autonomous Council, whereby it was held that the respondent number 4 had purchased a plot of land at measuring 0 bigha 1 katha 10 lechas covered by dark number 402/426 of patta number 279 of village Sikaria Pakar under Langfair Moza. By the deed of sale dated 13/1/2012. By the had purchased not, had purchased by a deed of sale or deed of gift.
Written purchase, once written gift it,
Yes, yes, Mr. Bulwa, what
not
is it?
confirmed.
Had acquired possession, acquired rights over a plot of land measuring 0 biga 1 katha 10 lecha covered by dag number ikini ko likile by virtue of a deed of gift. Thereupon, the respondent number 4's name was duly recorded in the Jamabandi in the office of the Assistant Settlement Officer / Assistant Revenue Officer of Puloni Circle. It is seen that from the materials on record, herein have been possessing over the land on the strength of a deed of lease between Sri Jongpong Rohang, which was, however, later on revoked. Be that as it may, by the impugn order dated 5/10/2016, the Revenue Court directed the Assistant Settlement Officer
9/9/2016 order.
5/10.
There is a memo number, order dated.
Oh, I did
9/9.
5/9/2016. The Revenue Court directed the Assistant Settlement Officer, Puloni Circle, to hand over the possession of the land to the respondent number 4. Being aggrieved, the petitioners had approached this court. Mr. P.C. Day, the learned counsel appearing on behalf of the petitioner, submitted that the Revenue Court authorities cannot decide cannot substitute the role of a civil court. Inasmuch as it is only in our proceedings before the competent civil court wherein a decree can be passed for recovery of possession. He therefore submitted that the impugn order dated 9/9/2016, whereby the Revenue Court had directed the Assistant Settlement Officer Puloni Circle to hand over the possession to the respondent number 4, is beyond jurisdiction. Mr. J. Sutia, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3, submitted that by an order dated that pursuant to the filing of the instant writ petition by an order dated 22/5/2023, the earlier order passed on the impugn order dated 9/9/2016 have been reviewed and
A direction to.
a direction have been issued only to the Assistant Settlement Officer of the Puloni Revenue Circle to demarcate the land measuring 1 katha 10 lechas covered by dag number 402/426 of periodic patta number 279 of village Sikaria Pathar (C) Moza Longpar. Full stop. The said order was placed before this court during the course of the hearing. Full stop. The same is kept on record and marked with the letter X.
Handed over the
Taking into account that the order dated 9/9/2016 have already been reviewed by an order dated 22/5/2023. Nothing therefore remains in the challenge to the order dated 9/9/2016, which have been impugned in the incident proceedings. Be that as it may, this court further finds it relevant to observe that the question of that the revenue authorities have no power to revenue authorities cannot, in the name of demarcation, disturb the possession of the petitioner over the land whose the revenue authorities can only, after making the demarcation, issue a demarcation certificate and also point out the area which can be duly recorded in a minutes wherein the respondent number 4's land is. This court further observes and directs that the respondent number 4 shall be at liberty to approach the appropriate civil court if so advised for recovery of possession of the land which is under the occupation of the petitioner, if so under the occupation of the petitioner. The above observations and directions the petition was disposed. Huh?
Or withdrawal of Appalatnama lordship. Otherwise, my lord, the matter has become infructuous.
Very well, let us see.
My lord, the basic contention of the petitioner is that under Thengal Kasari Autonomous Council, my lord, some villages are there, my lord, and they should not be disturbed. Like, my lord, I'm just placing this has been amended. The act has been amended, my lord, and that village council, my lord, has been deleted from this act. So now, my lord, overall less, my lord, Thengal Kasari Autonomous Council doesn't have any jurisdiction over them. They are prayer is, my lord, made up.
In something like that day which I
Yes,
passed that
exactly,
order of
same matter.
same matter, Thengal. That is what which Mr. Mahmood was appearing.
Mahmood, but Prabha Hassan,
Same time.
same thing.
Village council is out.
Out, my lord.
Village is out. That village.
My lord will come to this amendment act, my lord. Pass this to my lord, amendment of section 2.
Village council area.
That fund is out. Then
Amendment to section 48.
yes, my lord.
Huh?
Village council area, my lord. The entire village council, that village council word is gone.
The village council concept is gone.
So, my lord, basically now that was their grievance.
Mr. D. Chaudhary, the learned counsel submitted that the petitioners have been duly intimated that the petitioner that he would not further like to pursue the instant petition on the ground that there has been no instructions received from the petitioners. To the said effect, he has filed an affidavit enclosing therewith the correspondence and therewith the communication dated 31/7/2024, as well as the postal receipts. In further to that, it has also been mentioned that the said notice was duly served upon the petitioner on 10/8/2024. On the other hand, Mr. R. Dhor, appearing on behalf of the Tribal Affairs Department of the Government of Assam, had submitted that nothing remains in the instant petition, taking into account the amendment made to the Thengal Kosari Autonomous Council Act 2005 by the Thengal Kosari Autonomous Council (Amendment Act 2024), whereby the entire concept of village council have been omitted. Full stop. In that regard, he has placed the no. This court have also perused the amending act of 2024, and from a perusal thereof, it is seen. It appears that nothing further remains in the instant petition. Taking into account, taking into account the above, the instant petition therefore stands closed as it had become infructuous.
All right, I agree with
Put it in a sleep.
Production list item 2, promotion.
Yes.
Winners are shareholders of a cooperative society called the Industrial Cooperative Bank Limited. It's one of the older cooperative banks in Assam.
Which one?
The Industrial Cooperative Bank Limited.
Oh,
It is from 1950s onwards, they have been running their business. So what has happened, Your Lordship, is there was a dispensation under a particular person who was the then managing director. They sought to take over the affairs of the bank. They introduced an amendment to the bylaws saying that only people who have a minimum of 20,000 shares or 5 lakh rupees as capital, only they can be allowed to become directors of the bank. But against those persons, Your Lordship, FIRs were registered for financial misappropriation and they have been charge sheeted and trial is presently going. And the Reserve Bank of India initially took over the management of the bank by superseding the board, and then it was handed over to an administrator appointed by the Registrar of Cooperative Societies.
now it has been taken over by that some official,
By the Registrar of Cooperative, yes, when official
no,
appointed
by the directors have been there. Is there now? Because that day, another matter where they have to pay some amount. There was one council who was appearing for this particular bank and said that now we are having the directors who are going to take a call on the payment to be made.
we have approached this honorable court. Decision was taken under the management of the administrator by the who is the Deputy Registrar of Cooperative Societies and will hold elections. In the elections, initially, the responsibility for conducting the elections was given to the respondent number 8, one Ganesh Dekar, who is himself charge sheeted in the criminal proceedings. He is one of the prime. So he was given responsibility for supervising the elections as the chief executive officer. Immediately upon getting that responsibility, Your Lordship, he issued notices to the petitioners and other shareholders saying that you do not qualify and therefore you cannot be allowed to participate. Why your membership should not be terminated?
Where?
That notice, Your Lordship will find at page number 118. So after that notice, your lordship, we submitted representations before the administrator and before the
I have
registrar of
decided to terminate your membership from the list of members as per section 23, as you have not used the services for more than 3 years, nor attended more than 3 years, and have ceased to be a resident of the area of operation.
So after that, we submitted representations before the administrator and the registrar of cooperative societies.
Right.
The registrar of cooperative societies accepted our representation and said that yes, a voter list has already been published. We know what was happening, basically because there was no notices were issued under the previous dispensation. We could not have participated in the elections. Anyways, we were allowed to participate, vote and contest in the elections. 13 nomination papers were filed against 15 posts, so all of them were declared elected uncontested. After the elections, your lordship, the petitioners who are shareholders, they are not members of the board. They came to know 2 persons have been elected, even though they are ineligible under the provisions of the act. One person, your lordship, has a loan, even though he is a director in the name of his wife, which is impermissible under the both under the act as well as under the guidelines framed by the RBI, which are in place. The second person, your lordship, he has already been declared a defaulter. His loan, your lordship, because he had defaulted, was closed under the OTS scheme.
So they were 13. So
30.
13 got away
13 got it.
in view of 13(1)(a) of the rules. So they have got away, and the 2 secretly were brought in.
They are amongst the 30. There were only 13 nominated.
Amongst the 13, there's 2 were.
There is 2.
Then
We
you
submitted
agree
a
to the
representation before the registrar of cooperative societies because we came to know on the 25th. On the same day, your lordship, the minutes of the AGM were approved. Our contention, your lordship, is with these 2 persons because the bank, your lordship, has gone through a lot. In fact, the trial is still going on regarding the issues of financial misappropriation. Now, if these
Now,
two
what has happened to the election petition?
Your lordship, no order was passed. Lordship may kindly have our representation which we have filed because that is the only
When was the minutes?
minutes are dated 6/9, your lordship.
And when did you submit your representation?
Not known for that. And on the same day, without any order being passed on that
So
representation,
you are challenging the approval.
we are challenging the approval as well as the election.
Election, how can you do?
I understand, your lordship, but at least the approval, we are challenging both in the petition. But at least before approving the AGM, some order ought to have been passed on our representation.
But how do you take care of 15 days he had to approve?
Lordship, I understand within 15 days he had to approve, but since we had submitted the representation prior to that order being passed, at least that ought to have been
You
considered.
submitted on 25. On 6/9, it was the board's meeting. 15 days, if it was brought to the notice of the registrar, 15 days would expire on 21.
6/9, your lord.
6/9
Yes.
would expire on 21. So if it is on 21, then 15 days, otherwise also it will be deemed to be approved.
Deemed to be approved, your lordship.
Then how do you take care of this situation?
But since they have now passed the reasoned order, your lordship,
Where?
the order is passed, your lordship. At page number 160, not a reasoned order, they have passed the order approving the resolution at page number 167. So that issue of
67.
deemed approval would not survive anymore because they have already passed an order.
When the payroll, however, borrowing limit shall not exceed approved subject to finalization. Where is the order of approval?
This is the order of approval, your lordship.
Where?
With reference to the above, I am directed to convey the approval of the Registrar of Property Societies to the proceedings of the AGM of so and so held on 6/9/2024 with the following observations.
See, he is conveying.
Yes,
Approval has to be passed by the registrar.
this is the only order which was furnished to us.
Registrar will pass the approval has to be by the registrar. He is conveying. Can you actually issue notice? What is the urgency?
Our concern is that the lordship may kindly have a, if I may kindly take your lordship to the provisions of the, once the provisions of the master circular issued by the RBI, and your lordship is already aware of the provisions of the act. The RBI has specifically said that no person, a director in a cooperative bank particularly, should not have any loans with that bank, he or his family. Here is a case where this person has an existing loan. And even then, because the returning officer per se would himself not be aware that these kind of things have happened. This is the
Is a
one-
person interested?
Response number A who is a person interested and who is charge sheeted, who was given the responsibility for conducting the elections. And as a chief executive officer, he had a duty to place those records before the returning officer. That having not been done so, now they have been brought in, your lordship, and the entire process, the spirit of cooperation that ought to exist, your lordship, that will be completely vitiated by the entry of these two persons. Because the act also does not permit them, even the master circular of the RBI does not permit them to become directors.
What are they doing as regards the remaining two?
The rem-
Remaining two, what are you doing? You have to hold elections? What are you doing? Only 13 has been filled up then.
Remaining two, my lord, there is no nomination. Then nomination total
total 15. That meaning
13 nominations have been submitted. So there is a provision for voting.
There is a provision out there now by which you can you can bring in two,
Yes.
two by which that is also by way of an election or something.
No. Can
What
be,
is that?
can be done by way of election, my lord. But since no nomination was submitted,
Well,
So
it's
therefore-
okay, but then also where it will become expert. Case 41-9,
41
where there are vacancies in the office of the director and where there are no sufficient number of directors to constitute a program for the board. The board may co-opt maximum 3 eligible members for constituting the quorum or arrange for holding election to fill up the vacancies for the unexpired term. of the
quorum is 11.
Now, here the person is, we are concerned with this. There is another provision whereby a person cannot be, if he has the arrears. 43, such person has no pecuniary interest in any subsisting contract or working being done for the cooperative society except as otherwise specified in the bylaws. You come under 43.
Yes, and your lordship 543(5) as well. 45 as well. your lordship.
Is free from default of any payment to the society. These people are defaulters.
Walter, one of them has a subsisting loan in the name of his wife.
But that is allegation. We'll have to consider them.
Enclose the records of the loan, your lordship, along with the present petition also, and that was placed before the registrar.
What is going to happen in the meantime? This,
Your lordship, because if these persons are allowed to participate in the decision-making process, of particularly your lordship in this cooperative society where it was all along under the administrator lordship. Let it remain under the administrator lordship. Let the
no, how can it be under the administrator? Administrator cannot happen out there because we see how can the administrator is under 41-6? 41-6 cannot happen when there is a properly constituted board. But as of now, if I say that the administrator will hold, means I am negating the entire election. But can I do so at the interim stage without a notice properly? That will be not possible.
perhaps then the lordship may kindly then direct that these two persons at least they may be at least till the interim period is considered, they may not be allowed to discharge any of the functions of the director. At least these two persons. Then the quorum of minimum of 10 will be there, you know. At least these two persons, because they are
Quorum,
out of
quorum
50,
is 50%.
50%. So even if two of them go, 11 will remain your lordship out of 50.
But you need 6.
There are 11. There are 11 will,
There'll be no, there'll be 13. You need 7.
yes. There will be
7 for the quorum. You need 7 for the quorum.
these two, even these two persons are not allowed, your lordship. 11 will be there, quorum will be there for the meetings. But if these are people
So
who are,
you mean to say that this court should now, the interim, make it that the quorum would be 5.
no,
or 6.
quorum will remain as 7. What I am
How
saying
can
is,
you make it 7 when there are only 11?
no, there are 15. So quorum will be
Quorum is 15, but we have 13.
15, there are 13.
30.
So
Now,
50%
out of
of
13, you want to remove 2. which makes it the quorum would be 11. The moment I say that these two are out, means these two can't be considered. So the quorum has to be on the basis of 11. The 11 means 6.
Yes, your lordship.
So you mean to say that this court by way of interim orders will reduce the quorum?
My understanding is the quorum would perhaps remain the same, your lordship, out of
Oh,
50.
heavens will fall. Oh, heavens. Why? We will see when the notice is issued. Let's see. No, nothing, nothing. Huh?
It's an interim returnable. of sort.
Absolutely. We'll make it very clear on that.
And at least let note then no financial decision to be taken till the next day, your lordship. Then that at least your lordship. perhaps-
This will impact other petitions. There are many other petitions which are there pending. Well, because of your bank, a lot of people are suffering. And on one hand, I say that no financial decision. On the other hand, I have issued a writ to them. Then look here, kindly make the ear of these people.
Perhaps, I mean, of the quorum would be that the total number of directors would be 15. So even if two of them, because two posts are already vacant, even if your lordship does not allow two of them to discharge their functions during the pendency of this writ, even then the minimum which is required of 7, that will be fulfilled because 11 number of directors will remain, your lordship. Then those 11 people, your lordship, without these two tainted people, ineligible people, they can discharge the functions and take whatever decisions are necessary.
You have, who has become now? Ganesh Deka.
Ganesh Deka is the chief executive officer. And
He's no longer there.
He's there. He's the chief executive officer.
So whatever may be, but we are concerned with which
9
guy.
and 10. 9 and 10.
He's also the administrator.
So the administrator is somebody else.
9 is here, administrator to the administrator.
Yes, because I do not have their addresses.
Then? But the administrator is not there, then how do you solve it? As of now, there is no
Because
administrator.
they have not yet taken over charge, your lordship. Only
They
the
have
AGM
taken over the charge.
AGM has been held, your lordship. They have
Yeah,
not taken-
AGM, no, approval has come, they have already taken over the charge. It has been approved also, so they will take over the charge.
They have not yet taken over charge. Your lordship. I have specific instructions.
Can be. The charge is taken on the very day itself. It is approved subsequently. Within 15 days, it has to be approved. If not, it is a deemed approved.
But why I didn't to the administrator was because I did not have their addresses and otherwise the address which I have entered, which I have
Industrial Cooperative Bank, you are saying about represented by the administrator. How is it possible? Administrator also you have made a party. He no longer exists.
because officially charge has not been taken over by this new board of directors. The elections have been held. That have just been
Once it has been approved, first of all, the tenure of an administrator is under 41(6). The 41(6), the moment there is an election held, the person is being duly appointed. Would be deemed that immediately the power is shifted. That person would have no jurisdiction. How can you think about conferring a jurisdiction upon that authority?
Yes, the process of election is not over, your lordship, perhaps.
Election is over a long time back.
It will be only over, your lordship, after they take over.
They are sitting, Mr. Pathak, they are sitting. That day when another matter was a case where this was a case where the Industrial Cooperative Bank have sold a particular what do you call, land to a particular person. After selling everything, not selling it, agreement, everything done, payment made, agreement for sale deed was not made. And now they are not in a position to pay the amount. So therefore, I directed them to pay the 55 lakhs of rupees. Now the question is out here saying that we have already taken over charge out there by the industrial area, and as such, they are now going to revisit on the decision which was taken by the administrator. This happened a week back, and now you are saying
My instructions are that the meeting was fixed on the second, your lordship.
your instruction is very delayed. If you had the proper instruction, you would have filed the election dispute within 3 days. But how can you affect the service with the administrator in this manner? I think all these things may served upon that person concerned, the SS road.
The lordship may kindly,
And why you are making the other people a party?
I'm increasing the men's performer respondents because if your lordship were to stay the entire resolution, then they would be affected. They might be affected. So I have to increase it.
That is asking for the more. Issue notice. Let's see what happens. Issue notice returnable on 4th of November.
Lordship may permit me to take dusty upon them, then perhaps.
4th of November. Mr. S.K. Talukdar appears on behalf of the respondent numbers 1, 2, 3, 4. As regards the respondent number 5, 6, 7, 8, 9. As regards the respondent numbers 5, 7, 8, 9, 10, 11.
11 perhaps my learned friend can distribute.
Yeah, now appear to go, 11. Why are you making the returning officer again a party? I'm not challenging it. Anyway, 11. Yeah, appear go. 5, 6. 6 also has no business. Isn't it, Mr. Talukdar? 6 has come on.
Because charge was not handed over.
Charge fully handed over. 5, 6, 7, 8, 9, 10. The petitioner is directed to effect service by way of dusting routed through the registry of the spot by effecting the service by at the what is this office? What office is this?
Head of.
At the head office of the respondent number 5, which is located at SS Road, Laktokia, Guwahati 781001. For the present, this court is not inclined to issue notice upon the performer respondents, which shall be considered at a later stage if deemed necessary. The case of the petitioner's hearing is that the respondent number that pursuant to the notice issued for holding the election by the respondent number 6, the 13 persons, 13 shareholders of the respondent number 5, which is a cooperative society registered under the provisions of the Assam Cooperative Societies Act 2007, participated, and in view of the provisions of Rule 13(1)(a) of the Assam Cooperative Societies Election Rules 2019, they were declared to be elected to the board of directors in the annual general meeting held on 6/9/2024. It is also seen that this that the minutes of the annual general meeting dated 6/9/2024 were approved by the register of the cooperative society in terms with section
45.
45 of the Act of 2007. আগতে cooperative society লিখেছিল না for short then. The case of the petitioners herein is that the respondent number 9 and 10 could not have been appointed, could not have been elected, could not, were not eligible in terms with section 40 bracket 3 and 40 bracket 5 respectively, on the ground that respondent number 9 had a existing loan with the respondent number 4, and the respondent number 10 is a defaulter in payment of the dues to the respondent number 5. The counsel for the petitioner therefore submitted that the respondent number, the election of the respondent number 9 and 10 are liable to be interfered with by this court. On the other hand, per contra, Mr. He therefore submitted the pending notice. The respondent number 9 and 10 should be debarred from functioning as directors of the respondent number 5. Mr. S.K. Per contra, Mr. S.K. Talukder, the learned counsel appearing on behalf of the corporation department, submitted that the petitioner could have very well challenged the appointment of the respondent, the election of the respondent number 9 and 10 in terms of its Rule 27 of the Assam Cooperative Societies Election Rules 2019. In addition to that, the petitioners could have very well approached the register of the cooperative societies within a period of 15 days from the date of the AGM being communicated to the register of cooperative societies. The learned counsel submitted that in the instant case, admittedly, the petitioners have approached the register of cooperative society on 25/9/2024, which was even after the period of deemed approval in terms with section 45 of the Act of 2007. The learned counsel for the petitioner respondents of the Corporation Department further submitted that without hearing the respondent number 9 and 10, this court may not pass any interim orders. This court have given an anxious consideration to the respective submissions. And submissions. This court directs the, here you have the chairman.
Yes. The chairman has not anything.
There's no chairman.
The director, by specific instructions, the chairman has not issued.
This court directs the respondent number 5 to bring on record their stand by filing an affidavit on or before or by 30th of October 2024, indicating as to whether the respondent number 9 and 10 had incurred disqualifications in terms with section 40 bracket 3 and 40 bracket 5 of the Act of 2007 as alleged in the writ petition. This court further directs the Register of Cooperative Society to also bring on record their stand by filing an affidavit on or before 30/10/2024 as to whether its officials who as to whether the respondent number 9 and 10, on the basis of the allegations and the documents enclosed in the writ petition, are disqualified to be directors of the respondent company of the respondent number 5. In addition to that, the respondent number 9 and 10 is also directed to bring on record their stand by filing an affidavit. For the present, this court is not inclined to pass any interim order, as without taking into account the stand of the respondent authorities, it would not be proper, in the opinion of this court, to pass any interim order, as it would further derail the not be to pass an interim order. However, the interim order would be considered on the next stage. But you have a big problem. Today I'm in a good mood. Otherwise, I would have dismissed your petition.
Just one thing, where your lordship has recorded that respondent number 9 has a subsisting loan and respondent number 10 is the defaulter. It is the other way around. Respondent number 9 is the defaulter, 10 has a subsisting loan in his balance sheet.
It will go anyway.
Replay.
21.
Yes,
Yeah, filed their affidavit, your lordship, to bring
Who?
on
they have filed. Now,
we have petition.
what do you want?
We have filed an affidavit.
You want
Based
time
on
to file
record,
reply?
2 letters, one received from the bank and our reply to that, your lordship.
Mr. Sharma,
Yeah,
are you
not found.
want to file a reply?
Yeah, yeah,
It has been submitted that the Axis Bank has filed an affidavit.
I have filed your.
Oh, yes.
I have,
Yes, you have not filed.
but that has not
A
come.
certain instruction will be required, taking into account the matter and so on.
Yes, your lordship, we have rejected their proposal because they have given at the very initial stage 5 lakhs rupees. Still 9,50,000 odd is due.
What is the matter about?
Your lordship, we have taken in surface action in this matter
Then,
and they have come up with this instant writ petition on the ground that his son is left the house and he is no more traceable.
They're missing since 8 years, your lordship.
no, what is this? Calling upon the respondents shall not be issued, directing the respondents to quash the proceedings before the DRT and or directing the respondent to keep the loan account of the missing son of the petitioner in moratorium until a finality is reached. So, missing son, and they were the guarantors.
No, my son, your lordship,
Uh,
has been missing since 2015. So since now
He had taken a loan.
Yes, sir, also.
He had taken a loan.
He has a house property loan.
Then you want to take action on that.
Yes, sir. Already initiated 13 action.
Then?
Under Circus Yard.
Then
Then thereafter they have filed this instant writ petition. And they have paid initially 5 lakhs rupees also.
by here. Then
Not here, in the bank they have to pay.
then
They have filed one proposal also, which we do not consider because of the valuation of the property is much more higher than the total of this time. So we have asked them to improve their proposal.
oh improve. You are enjoying an interim order. Oh, improve.
Otherwise, we are
You want do you want this court to dismiss your petition
This is
today?
the letter we have
No, Mr.
Yes.
Sharma. Do you want this court to dismiss your petition?
on 5th of September, Your Worship.
List this matter. So it has been submitted by the counsel for the Axis Bank, Mr. M. Sharma, that has been a proposal being submitted by the petitioners. However, the petitioners the Axis Bank have asked them to submit a better proposal. The above shows that there is some negotiations going on in that matter. Accordingly, this matter again on 16th of December 2024, interim orders passed earlier shall continue till then. 22. Eviction?
Eviction.
Evicted?
No, my lord.
Where is that order?
It's a notice.
Eviction by whom?
Notice, my lord, also will find. And 23.
Page?
23, my lord, the vernacular one.
As per rule 18(3)(a)(1) and as per the government notification, you are intimated you have illegally occupied the land by Sarkari Dark number. Therefore, you are asked to vacate the aforesaid within 30 days. Then, what is your stand?
I have to appeal instruction also.
Okay. We make it absolute. Allow their repetition. Quash this notification, notice.
The matter is came up before this honorable court after long interval also.
So you must have forgotten, take fresh action if you deem fit. That is what. Have you got the settlement?
My lord, we have applied.
That was one time back. When you apply for settlement, the settlement proposal has to be decided within 330 days. What happened?
Under their consideration. What
They
happened
don't
to
consider.
them, they have not
In
informed
the
us.
application only it is given. So he has applied for settlement. Don't remove him.
Have annexed the copy.
Let him remain for all times to come. Give him settlement. No instruction is there. Why should I? Not necessary. Nowadays, the 18(3) has gone for a 6. You are to take action as per 18(2) if you want. 18(3) has become useless. Issue a notice if you want to evict him. Issue a notice. We set aside this. Issue a notice properly. That why you should not be evicted. And then find out. Ask him to produce all documents on the basis of which he claims. Or we do one thing. These type of matters can remain forever. It is seen that in spite of notice being issued on 30/9/2020 and there being a stay to the impugned notice dated 28/7/2020, the respondents both in the revenue department as well as the district administration have not given any instructions to the councils as well as nor filed any affidavit. The above therefore shows that the respondents seems to be not much interested in respect to the notice for eviction dated 28/7/2020. However, for the interest of justice, this court grants an additional opportunity to the respondents to bring on record their stand to list this matter again on 27th of November 2024. Interim order passed earlier shall continue till then. What happened? Printing survives. What survives? No stay.
This regarding settlement of a San Mohan.
So, what
Participated
remains?
in the process and the highest bid amount. So our offer was considered. So our right accrues on the basis of two particular document, Annexure B and C, madam. Annexure C is the comparative statement.
Hmm.
And serial number 1, Jumna River Sen Mohol at Bottom Bagan.
It was given to whom?
It has not been given to anyone.
Then?
But there was a move
Hmm.
to, I mean,
So what remains now?
It was not given to anyone, my lord. It was not re-tendered also, my lord. In that particular area, my lord, local people, my lord, they are performing puja, so we have not settled to that area, my lord.
Nothing.
That is the instruction.
well, there is nothing on record. That's with
The
this.
lordship may record my statement or we can file it by way of affidavit also.
Nothing remains.
Nothing, my lord. It is a
2020,
2019, my
you
lord.
have no right.
19,
As per the tender also, it is cancelled.
not
It
issued
may
to
be
anyone.
withdrawn. You see the tender papers here, accompanied by here anything, the tender offer, it has, will be given out here somewhere, they can withdraw.
And he has already been allotted to another San Mohol, my lord, in that particular river, Jomuna River, San Mohol Samoguri. But in the Kadam Bagan, my lord, we do not. No one has been settled.
Annexure B, your lordship may only take note of, and Annexure B, whereby approval was sought from the authority of the council.
Approval not granted.
Approval at that juncture, file this petition. Immediately thereafter, nothing has been done.
Was it given to anybody?
It has not been given so far. Our information.
Where is your violation? As of now, where is the violation? Your violation will happen if it is given to somebody when you are the highest tender.
Yes,
It has not been given to anybody.
but there was move.
Move is there, the move has stopped. He says that he is not going to give. Well, see, nothing.
Their plea is that they are shifting the location from this place to some other place.
And re-tender will be issued. my lord,
And
for that.
that very fact is not there on the record. This is my
He has also
submission.
the information. He has also the information. He has some other area. He has also the contract of San Mohol in that particular river, my lord. But in this particular area, we are not.
No. Mr. So and so, R. Sharma, the learned counsel appearing on behalf of the petitioner. As well as Mr. J. Sutia, the learned standing counsel of the KAAC.
For number 225.
The petitioner herein have approached this court on an apprehension that in spite of the fact that the petitioner is the highest tender, highest bidder in respect to Jamuna River San Mohol at Kadam Bagan, there was a move to allot, to grant the contract to some other person. Mr. J. Sutia, the learned standing counsel appearing on behalf of the KAAC, submitted that the department is not inclined to grant the tender the allotment to any of the bidders, taking into account the
Taking into account that it is not, local peoples are not allowing to extract sand in that particular area, my lord.
taking into account that the local people have not permitted the AAC to extract sand from that particular sand mahal. Sand mahal.
Shift it to another.
Pushta. Under such circumstances, the KAAC have taken a decision to shift the sand mahal to some other locality. Pushta. Taking into account the above, the apprehension of the petitioner no longer survives, and accordingly, the instant writ petition stands. The instant writ petition have no legs to stand on its own, and accordingly, as the apprehension no longer and accordingly, the instant writ petition is closed, being devoid of a cause of action.
25.
Exactly so. But the matter relates to the payment of gratia, my lord. In respect of my lord, extremist feeling of petitioners brothers, my lord.
Hmm?
Earlier, my lord, rupees 1 lakh was, my lord, paid by the Dr. Basa, and now, my lord, balance amount of rupees 2 lakhs is, my lord, she is entitled to one.
Where is my similar orders?
Covered with similar order.
Where is it? My order,
No, my lord. Other orders, sir.
this is the matter of publication.
I have 3, 4 other orders, my lord.
I have passed many orders. It's a matter of publication.
Publishing.
No, because so. This one. We'll keep it for some time, find out. Before rising, if you can find out one of my orders. এই বিজয় কৰিব এইটো 2 লাখৰ এইটোতে আছে নহয় এইবোৰ এইবোৰ This is Boroland?
No.
Where?
Caribbean law.
Caribbean Anglong. Extremist এটা killing or কয় যে 2 লাখৰ expressious. চাব পাৰে. Yes. Find out by 4:30. This will otherwise goes after which.
26 carrying it is a matter also becoming substantive. Matter has becoming substantive.
The learned counsel appearing on behalf of the petitioner submits that the petition has become infructuous. So, taking into account the above, the Muslim petition stands closed as it has become infructuous.
May I proceed? My lord, by the order dated 14/8/2024, the petitioner was directed to deposit 20 lakhs 84,840.
What are you challenging?
I am challenging the rent they have claimed along with the GST.
Huh?
rent along with the GST portion, we have service.
Your challenge, GST.
Yes.
Please, Lord. Lordship, there is a clear cut direction, Lordship. They have to pay amount of rupees 20,000 for 20 lakhs, 84,000, Lordship. Within 27th of August, Lordship.
Where is that order for you to pay with GST?
That is in my reputation, I will maintain.
Huh?
The reputation I will maintain at page 28.
Page
28.
28. Yes, what is this? Service tax.
GST. Page,
There is a clear cut direction. We have already taken the step, Lordship. I am for the respondent. of
page
this.
31, your words, see,
Month.
GST.
Okay. So they are asking for GST. Then
Yeah, we have challenged that portion.
why?
Actually, we are agreeable to pay the actual rent.
Uh,
And in this petition, we pray that the so far GST part is concerned,
where is your settlement? Where is your agreement?
the agreement I have.
Your petition should be dismissed on that ground only. Where is your agreement? Without an agreement, you are asking that the GST should be there. GST has to be brought within it. There's no way out. And why are you here?
As because there is a clear cut direction, Lordship, we have already taken the step, Lordship. I would like to furnish.
Have you evicted or not?
No, Lordship, we have written a letter to the respondent number 5 to take action regarding eviction, Lordship.
Phone number 5 is who?
Five is Lordship.
Who is respond number 5?
5 is Lordship, Industry and Commerce Center, Lordship.
How will the respondent number 5 take it? You see, there is a procedure, na? How you evict?
That's why we taken the step and go to
By the estate officer.
Yes, Lord.
The state officer will have to take action.
Yeah.
Well, take it. Why, Mr. Sharma, we should at all entertain this petition now?
No matter your lordship can.
First of all, the GST has to be paid.
Yes, Lordship.
No matter
There's no quarrel with that.
If your Lordship,
No,
comes
my
to
lord,
the, paragraph 11 of order dated 14, Lordship, 14/8/24.
It also provide the other components which are required to be so added to the monthly rent receivable by including GST and social bill.
no matter
Regarding that, we have that updated instruction. Lord.
my lord, your lordship can receive. By the order dated 18, I was directed to pay rupees 20 lakh 84,814. 14.
Mr. Sharma, what you are trying to do is, before any proceedings is initiated and by the estate officer, you want this court should adjudicate. Why? Why should this court adjudicate? When an estate officer takes up the issue out there, you take it up, pay whatever may be. That is your lookout. As of now, why should this court entertain 226? A state officer will take up because they cannot take the action otherwise by law. If it is a public premises, it has to be done as per law. Public premises. They will issue a notice, you reply whatever you have as to whether it is payable or not. Appeal lies before that with the DC. DC then we come at the third stage, and now you are just preempting this court to decide now and then what happened.
Only your lordship kindly bear some time.
GST, this court is going to take it
No,
up.
no,
This court will
not
decide
only-
that you have to pay the GST. Once I have to say that if you are to pay the GST, because GST has to be paid, that is by operation of law you have to pay. Whether
my
you
lord,
pay, don't want to pay, that is a different question, but you have to pay by operation of law.
holding in this matter, I am also a defaulter in payment of that. So this court directed the petitioner to pay 20 lakhs 84,840. That amount I could not collect and pay within time. So I therefore pray by tomorrow or day after, I shall deposit this amount, 20 lakhs 84,800. For this prayer only I applied.
No, where does the question of this court permitting you? You were earlier asked to pay. You
Yes.
did not pay.
I could not collect the money because
It is your lookout.
uh,
You are holding to a property of the government which is being given to you at a very subsidized rate. And
that-
then you have,
yeah,
if
that
you are
part
not
too-
paying, what right do you have?
so, Mother, that part we are not disputing, Mother, that we are in fault.
There is no stake.
It says there.
Huh?
If, because they fail to pay, then you're not telling us to take action.
So I
Within
may
the
be
time
allowed,
limit, Lord.
I may be allowed 3 days time to deposit 20 lakhs 84,800.
Where? As of now, he says that you are liable to pay 64 lakhs.
No, this court has so logically look to order dated 14/8.
As agreed by the learned counsel for the party, the petitioner shall within 10 pay the amount of 20 lakhs by demand drafts and so, which you have failed to pay.
Yes.
If the payment is not made, it is reiterated the payment so and only and shall be without prejudice to either of the claims. So yeah, in the event that you are making the payment to status quo as regard to said under remand. So payment failed. Take action.
Therefore, my lord, I pray that at least 3 days time may be allowed.
This court would be reviewing this order. Why will this court extend? Even when the matter came up on 2/9, you did not appear. What to do?
Timing is very, is it there? They could not, they will pay by tomorrow or day after.
No, no, one last occasion, they have not paid.
Mr. Sharma, if you ask, I'll reject it. If I reject it, it will be put in the order. If you put it in the order, they get more strict.
My lord, in that case, I leave it to us.
Because you did not ask for filing an IA and asking for extension. Then why should this court at all? You were supposed to pay on 27/8. We are in the month of, tomorrow it's October. Then the court made it very specific. and clear.
Yeah, sometimes without IA, the court has ample power to exercise its power.
No, this court is not going to do that. Because this would amount to reviewing the order now passed by the coordinate bench. And that too when both the parties had agreed. And they are claiming 64 lakhs. What to do?
As your lords.
Should I record that non-payment has been made, or should I say that list the matter of vacation? Which? You are a civil lawyer, know what to do. Because the moment I say about anything about the amount, they will get the ear. This court is not going to extend it. .
thing is that there is some GST and late fee on it. And this could say that on this day, that will be considered. We have the updated instruction also.
You see, if they want to take any possession, that has to be done on the basis of the estate officer initiating under the public premises. Why didn't you take up the thing as regards your defense there? As of now, I can't do anything. You were asked to pay, you did not. Come on, take us action out there. There's no illegalities on the part of the respondent authorities. If I observe that he says that this amount has not been paid, I can very well say that if it is not there, it is open to the respondents to take steps. But however, the steps should be taken in accordance with law, meaning thereby by us, and the petitioner will be at liberty to take all defense as available. Don't you think that would be better for your client than to ask here? Because this court is not going to extend that period. I never understood immediately thereafter you file an IA that okay, I couldn't pay. We are in the month of September. Is the matter after vacation then? They will do whatever they can do. It's the matter after vacation. Yes, Mr. Nath. What about the payment?
Well, I have received the instructions, payment has not been, payment has not been disbursed. They, the fund has not, they have not received the fund from the board. The fund has not been received by the board. Some process of revalidation is going on. I've received the instructions, but some time is required for payment.
Well,
But I'll pay for 4 weeks time. I'll pay for 4 weeks time. They said that they are in the process of revalidation of the payment. And after that, the fund will come from work and it will be disbursed to the petitioner for the remaining portion of land. Madam may keep the matter in the first week of November.
the Learned Council appearing on behalf of the PWD NH Division, Longya NH Division submits that the certain further there are certain formalities required to be complied with, and as such, a 4 weeks time is being sought for, so that the fund could be disbursed to the petitioner. To list this matter on 6th of November 2024. In the meantime, the respondent authorities shall apprise as to whether the said amount have been disbursed to the petitioner. Yes, Mr. H.K. Das. What happened? How? What is to be done in this case?
Well, before my learned friends subjects, may I point out? Well, already we have apprised this honorable court about the fact that my daughter is in a executive and a chemical state, so she cannot come into the family court before the family court. So the mother has filed a petition before the registry of the family. The family court registry said that unless the petitioner comes before the honorable court, there is no procedure for accepting this petition. We submit before the learned principal judge, although no order has been passed, that you see under section 10 of the Family Courts Act, there is a provision that you can have your own procedure, and this procedural law should not be a hurdle to accept this petition. Let the court decide the merit of the petition later on. Now, on the last occasion, your lordship has raised a very pertinent question that what is the law in regard to that
Physical Disability Act of 2016, which was subsequently amended in 2018, and the Mental Disability Act, vis-a-vis the Guardians and Wards Act. I'm obliged to your lordship that your lordship has raised a very pertinent query. And after going through the acts and the provisions of the Disability Act, as well as the Mental Health Act, as well as the Guardians and Wards Act, so for a person who is in a vegetative and a comatose state, there is no provision to deal with such a situation. And your lordship, in one of the judgment of this honorable court, there is a discussion that so far the vegetative and comatose state is concerned, it has been discussed in the famous euthanasia case of Uruna. By applying the doctrine of parens pacria, the court can always, under Article 226, can invoke the jurisdiction and give directions accordingly, and it has given. And that judgment of this honorable court has already been referred by Telangana High Court bench, referring to the judgment of this honorable court, because this was a path-breaking judgment so far this honorable court was concerned. But prior to that, my lord, there are innumerable judgments of the Bombay High Court, which has dealt with this type of situation when a husband has made it an accident, the wife has come, someone have neurological disorders, and there are various. I have got the list of all the cases. I will place those judgments. So far my case is concerned, my lord, I'm not on appointment of the guardian. My case is that so far the family court registry is concerned, it should accept the petition and let the court decide there. And so far the merits is concerned, whether I have filed a petition for maintenance under the 125 Act, the DB Act, all those contentions of my learned friend can be taken care of. And I'm obliged to your lordship. Your lordship will kindly look into this judgment of this. Your lordship will recall. Your lordship has to look into the SCC online.
Why?
We're referring to SCC online only.
I don't have it. Where are the judgments?
Yeah, the first category of judgments I have given on section 10 of the Family Courts Act. The next on section 125 CRPC and DB Act. That I think the Family Court should determine. And the next is on that euthanasia judgment of Aruna Ramachandran I have given, because the concept of vegetative state and the comatose stage has been discussed in paragraph number on those paragraphs. And then this judgments and the comatose vegetative heading are all those cases where the—
What is the situation of that person? That your client
she is in a vegetative state.
is in a way. So under such circumstances, for permitting your mother to file that application,
Yes.
wouldn't it be required for your mother to be appointed as a guardian?
My lord, so far guardian is concerned, my lord, that also your lordship can direct by invoking the powers under Article 226, and in appropriate cases, your lordship has done it. Your lordship can mount the relief accordingly. There is no problem on it. Your lordship can also, if someone has doubt regarding my vegetative state, your lordship can also direct a medical board to go and see whether I am really in a vegetative. Your lordship has enough power under Article 226. I need not remind your lordship that your lordship can invoke that jurisdiction by on the basis of the principles of parens pacria.
No, that can be done, but the first thing is that somebody has to represent.
Yes.
Who should represent?
Mother.
There has to be a court's order.
Your lordship can always direct.
I can direct very clearly, but you have to ask.
No, no, my lord.
You have to ask for that the court should pass an order to that effect that they should, so and so would be the person. Because you see, when you are invoking this principle of parentage, you have to also take note of that this person would be dealing everything about that person who is not in a position to do anything. This has far-reaching consequences without being asked. If this court be appoints, tomorrow anybody may say, look here, who is the court? Merely because of Mr. B.D. Kaur, senior advocate standing out there, this court has passed the order.
My lord, see, my lord, these are the type of litigation where
These are the type of litigation. No, Mr. Ford, you have to understand that
I
these are
appreciate,
types
madam, I
of
appreciate,
litigations wherein councils have to be more careful
No,
because
Madam,
you no, there's a reason why.
Yes, yes.
What will happen to the person if, just for example, if I put it as a precedent that without an application I will appoint, what stops that in every case this precedent should not be followed?
Madam,
And if that precedent is followed, it may lead to a dangerous situation.
Will not trouble your lordship to go into it. Your lordship will give us just 1 day time. We'll file an application. This technicalities.
No,
far
these are
this case, it can be
technicalities.
taken care.
These
It can be taken care of,
technicalities-
my lord.
No, this is a very important aspect.
Yes, we
You
appreciate
have
your
to
lordship's.
appoint somebody
Yes, we'll file an
who
appropriate
would be
application here. my lord.
and along with that, that person also has to file where the documents.
We'll file an appropriate application seeking for appointment of the mother as the guardian before the honorable court. My lord, we'll do it. That's
You file an IA out
yes,
here.
yes. Yes, my lord, that's that tech, because my lord, see, on the last occasion also, these are the evolving laws. My lord, prior to 2018, nobody knew. My lord, the first judgment on this respect came only in 2020. Even I had never had occasion to deal with it, my lord. And this was the first time then when your lordship made that query, we go back home, burn our midnight light, and then we look into all these provisions, my lord. So this is, so I can take care of it by filing an IA. It's not a problem, madam. I don't have any ego
No,
issue on that.
You see, here may be a case, the certificate which is being given by this person is from some diabetic clinic. He says that the patient is unable to write and speak. But what about she giving means she's in a position to express by way of any signs and symbol. For that, whether she would like to be, these are things which needs to be also looked into when you file an application.
Yes, my lord. So far, this is concerned. My juniors have physically gone and visited the lady. She is in a vegetative state. When her daughter, who was taken away by the father, she was a kid. Even she, when she came, she could not speak anything and do anything. Only they could see some tears coming out from her eyes. This so far, in terms of the court order, we went. My juniors accompanied to their home, and this case is, so far I am concerned, it's completely pro bono for me, and I'm obliged to my juniors also that they have done this work as a pro bono, considering the nature of the litigation that is before your lordship. And this small technicalities can always be taken care of.
We will not.
We will.
No,
No, madam, no, I'm using it just to.
Mr. Kaur, these are not small technicalities. These have far-reaching
No,
consequences.
you're not. Even
You
if
are
I
asking
say,
that a person should be a guardian
Madam,
of a particular
yes, yes,
person
yes.
who is not in a position to hear.
yes, ma'am.
The person may not be even for the welfare of the person concerned. One has to look into it that overall who should be the person concerned who could be in a better position to take care of this person.
Yes, I
These
have.
are the various aspects
Madam,
which
even
needs
if
to
I'm
be.
with
And for that, one has to file an application requesting this.
it, my lord, that technicality should not stand in the way. We'll do it. We don't have any ego issue in filing an application. for
It
this.
is not a question of ego issues. Your petition otherwise is not maintainable.
My lord, your lordship will say, your lordship can always mold the relief.
All the relief is molding his relief is there. Yes, a person today was fine when the petition was filed. During the process, he has become paralyzed. He's gone into coma. This court then will very well take it out on its own and pass appropriate orders how to do it. But here is a case, here you are approaching. Then look here, I want to file an application before the family court on behalf of my daughter, which has not been accepted. She is in a bad order. If you want this court to give you that permission, you have to ask for that relief.
We'll ask for it. My lord, I always feel that my lord, learning is a never ending process. My lord, we learn. Only when we stop learning, we think that we are no longer young.
Learning also includes filing the proper application.
No, my lord, all this law have developed after
This
2020.
law is 6 years back.
No, the 2022, I have find all the judgment of the Honorable Division Bench of Bombay High Court here. delivered by Justice Ujjwal Mia sitting in the division bench, which was a path-breaking judgment. And your lordship judgment is now being followed by the Telangana High Court. Recently, only Telangana High Court had one such case to deal with.
Because if you see my judgment, I made it clear how it is to be taken.
Yes,
That
yes, I have seen the
lady-
part.
You see, the lady concerned was first, we sent a particular person out there looking into from the official as to what do you think about that? When that particular report came up before this court, then in that regard, this court passed an order to the effect that how it is to be taken. These people are to be, how they, then also it was given in such a manner, the order was such a manner so that they can't spend that money for any other purpose. You see that?
Yes, yes, I have read line by line, word by word of your lordship judgment. Well, we can
Therefore,
take
you
care of
file
it.
an I.
Yes, yes.
Mr. B.D. Kaur, the learned senior counsel, appearing on behalf of the petitioner, submits that the petitioner would like to file an interlocutory application seeking permission, seeking an interlocutory application so that this court can apply the principle of
Parents Patria.
the spelling.
Parens Patriae.
Spelling to accordingly when
We'll find it within tomorrow.
spelling.
Considering the urgency, I can file it by tomorrow. For me, it's not an issue, but I can stop all other work and file so for this case.
2020. 21, 23, 10, 2000.
May I take back the list of citation? I'll update it later on.
I hope you can very well later on take another printout.
And nowadays we are not wasting papers.
Much.
Yes, what is this?
But my limited prayer before your lordship, can you see page 32. But we have filed a representation before the deputy commissioner. Page
What
32.
is it? Asking for what?
Yes. Now
I
under
think
rule
we need the name of the
116.
respond number 7 to 9 from the land measuring area. Why should this court direct?
Because they have no possession and under rule 116 the deputy 116 1986.
Ah,
The deputy commissioner is the competent authority to take decision to delete the name of the person who are not having interest, right, title and possession over the particular plot of land.
Then?
That since the deputy commissioner is the vested authority, my lord, if your lordship direct the deputy commissioner to pass an speaking order after hearing both the parties, that will suffice the case, my lord.
no. What are you asking for? I don't understand. First of all, some order is being passed by circle officer.
Circle officer.
Where is it?
Now that lordship will find at page, my lord, we have annexed the my lord,
23, 2022. Where is that? What? Where? Why are you invoking this court's jurisdiction?
because the deputy commissioner is the competent authority.
So,
to delete the name of the person who have no interest, right, title and possession about the particular land. Since somebody's name has been incorporated in my patta, so their name should be deleted after hearing parties concerned.
you are referring to rule 116. 116 has nothing to do. If a person is not there in possession, you may strike out the mutation, not further beyond that, because mutation is to be given on the basis of title and possession.
Yes.
That is the basis.
That is the basis.
But for that, the proceedings have to be initiated before the deputy commissioner. Have you initiated that?
My lord, we have filed, my lord, application, lordship will find page 30,
Representation.
page 30.
It's a representation.
Yes, my lord.
So representation, that doesn't work. You have to file an application properly. What is this type of applications?
Prescribed form, my lord.
Absolutely.
My lord, we will file, my lord, prescribed application form, my lord, before the deputy commissioner.
The learned counsel, Mandal, the learned counsel appearing on behalf of the petitioner submits that the petitioner would be better advised to file a proper application before the deputy commissioner. And not the chairman. It has to be before the deputy commissioner because the order has to be passed by the deputy commissioner. And this and against that, an appeal lies to the Board of Revenue.
Board of-
So, my lord, may I submit only? Because my lord, circle officer passed the order. So under 147 Assam Land Revenue Regulation, they have to file appeal.
That is a different thing. They are not going on the question of an appeal. You want to file an appeal?
No appeal.
They are going under 116. 116 is the provision by which when you file it before the deputy commissioner, you can ask him that, look here, this person has no interest, no possession over the land. And as such, you strike off his name. And the moment that name is struck off, whatever consequences follow, this is it. But that has to be done only after hearing.
Yes.
It has to be a proper application, not in this representation.
We will file, my lord, proper application in the prescribed form.
Samuel Mandal, the learned counsel appearing on behalf of the petitioner submits that the petitioner would be better advised to file a proper application before the deputy commissioner, district commissioner, Kamrup Rural, in terms with section 116 of the Assam Land and Revenue Regulations for striking out the name of the private respondents. He therefore submits that he would not further press the instant petition, but rather take appropriate steps in accordance with law. Taking into account the above, the instant writ petition stands closed on withdrawal. Liberty, however, would be there upon the petitioners to file appropriate application, and the withdrawal of the instant writ petition shall not prejudice the petitioners.
Development. On withdrawal, it is dismissed.
33.
But this petition,
It's
while
closed.
withdrawn, it may be dismissed.
It's closed. Withdrawal is when I go out there in bench one. Withdrawal is dismissed, not here. Yes, Mr. Angura, what is this?
This is the.
Oh,
case,
this one.
7 days.
What is that?
Mr. Bigo is on leaves on court number 4, my lord. But pursuant to the last court's order, my lord, we had received our instructions, my lord. May I produce before this honorable court?
Have you looked into my earlier order?
Yes.
Now, at what time you were required to pay?
My lord, there is that procedure when there is a detention, the goods are detained. Immediately after detention, there is a form issued with manual or online that regarding a provisional assessment of the tax of to be evaded. Thereafter, formal notice goes of the penalty, specifying for the first time the penalty, that is MOB 7, I believe. Thereafter, that option comes for the SST immediately pay and get the goods released
Then,
without protest. There, if the goods are released without protest, the proceedings are concluded, the SSC has accepted his fault, this is concluded then and there itself. If it is not done, then MOB 9 is issued, which is a show cause notice demanding the penalty, final penalty assessment.
then you submitted when? When did you make the payment?
But I have given the payment details, my lord, and this is a challan slip on 10/11/2023 itself.
10/11/2023. Then, did you make the payment on the protest?
My lord, yes.
Where?
My lord,
At the time of payment, did you say under protest? Because there is a difference out there. Kindly see, if it is a case on the 129.4. Then in the 129.3, there are two aspects. One is the case of penalty and one is the case of payment of tax. Now, while passing there is a specific order to be passed in the case of the penalty. Because otherwise there cannot be any imposition. Now, when you issue the notice under 123, 129.3, in terms with 129.1, and the payment is made under 129.5, without any protest, what remains? Did you make the payment prior to the reply or after the reply?
The same date.
Yeah, why?
This is earlier first, my lord, because this notice is given on the same day, 10/11,
Huh?
page 47, my lord.
Where is your payment? Let us see.
Is that page 50? Deposit
At
time.
the outset, it is submitted that the present so-called notice is bereft of Iman. Iman in the foregoing, it has been saying that the released, that the goods and AR may be released after due withdrawal of the present so-called notice in the same is not possible then finally issue the check. Putting the months to enable the applicant to submit, get the goods released and to deliver it to the same terms of nature. Then did they kindly issue the challan? Did they issue the challan?
Take up page 51, the next page, the procedure that they have subsequently come. Just so and
The
so,
goods conveying so and so, carrying so and so, and after inspection of the detention and so was served to the Iman. Come forward and made payment to the people.
the work that is drawn. They have drawn up proceedings, not concluded.
Huh?
But if they have drawn up the proceedings, they have not concluded the proceedings or finished up the proceedings. So the next step is a issuance of the MOV 9 form.
When did you write this election 9?
Selection 9,
12.3.
12/3, my lord. But the prior to that there is another letter, page 47. I have contested the endings.
This is dated
This is
10/11.
10/11.
This is before payment.
This is before payment.
When did you make the payment? The date of issue on 10/11 of the so-called notice payment made within 30 days of the issue. Reference here, date of issue 10/11/2023, under which the voluntary payment is made 129.3. Cause of payment so-called notice. And so now, date of debit entry in 2023. Okay, then payment received. Now, how did you make the payment? Why did you ask for the challan? Kindly issue the challan for depositing the disputed amount. Why did you ask for that?
Because first thing is detention. When a detention comes, we have to take account of the fact whether the goods are perishable or not. Delay, if I don't have the challan, the goods will not be released even if I made the payment.
You see, if the same is not possible, kindly issue the challan for depositing the disputed amount. So you can pay after issuance of the challan.
Because challan contains the consignment particulars, because the seizing officer.
Mr. Burua, you are not understanding the point. I'm asking you, why do you need the challan for depositing? Or you can deposit on your own.
Challan, that is at page 48, my lord.
So this is the challan issued.
This is the challan issued. my lord.
Intimation of payment made voluntarily or made against the so-called notice or statement. So this is against show cause notice. Okay, cause of payment. Okay. Then, yes, Mr. Bogoi, how do I help you?
Three, page
Ah.
48.
Ah.
DRC 3, it says that, my lord, intimation of payment made voluntarily or made against the show cause notice, so and so. So, my lord, pursuant to this, he has made the payment.
But it is
Now,
again, it is
129.
not being shown voluntarily. Kindly see, cause of payment
Yes, my lord.
at page 48.
Section number 2, yes,
Cause of payment, page 48.
yes, sir. For the payment.
Cause of payment is show cause notice, not voluntary. So then how do you apply 129.5? And if you can't apply 129.5, you have to pass the order under within 7 days.
No, my lord, I say is, my lord, so far as the DRC 3 is concerned, even after getting the show cause also, he can make the payment.
Yes.
The only thing is, yes, 129.5 will have to pass an order.
129.3, not 5, 3.
Approximately 129.5 also.
No, no,
Says
5 is
payment
different.
from
5 will
129.3.
come at a later stage. That if a proceed upon payment, if it is being made, then they may drop the proceedings.
Here he has made the payment.
Understood. But it is here there are two aspects. One is voluntarily. You see, when the legislature use it, voluntarily show cause notice.
That's
Now, the reason for the in the challan has been mentioned as show cause notice.
yes.
So he's giving in the protest, not voluntarily. If it is under protest, then you have to dispose it off.
No, he says well, or voluntarily or made against the
Or
show cause notice.
made against. Therefore, when it is or being given, there are two options. One may give under voluntarily. Once it is voluntarily given, matter ends. Or so cause notice is being given. Therefore, the question arises that you need to adjudicate, but he has made the payment.
Or statement. One more word. Or statement.
Or statement.
Yes.
What do you mean? Now, here is a case where he has issued a letter to you
That's it.
on at page 47, Annexure 6.
Yes, ma'am.
This letter has been issued to you. And on the very day thereafter, the payment has been made.
10-11, yes.
So this is against your show cause notice, which was issued on 10/11/2023 itself. So you were to pass the order on 10/11 to within 17/11/2023. How do you take care of this situation? Anyway, we'll have it after vacation. Better.
I was of the impression that amount has been paid. So under 5, nothing remains, madam, because he has
Therefore it is. If it was in this document at page 48, if it was out there said voluntarily, cause of payment voluntarily, then the question would have been different. Nothing remains. But if it is against a show cause notice, contesting a show cause notice.
section under which voluntary payment is made.
Yes.
103.
So therefore the problem there arises. Anyway, let the government retain that amount of 6,51,000 for a week for during the pujas. What do you say? After pujas, you return it. Mr. Bolwa, anyways, he would not insist on the interest.
Be glad to get a refund.
Huh?
We'll be glad to get a simple refund.
Difficulty when there is a transport. Government
You file the appeal now.
Look, we have to file that. We have to, I have yet to get the instruction. We have tried online.
In fact, after my order,
Yes.
recently the Supreme Court also has come and passed an order also. This is very recently, 3 days before, bench of Justice Sandeep Mehta and the same order was passed. Similar order. This was passed on 24/9/2024. In the case of Sunil Bhakt versus Assistant Director of Income Tax, CPC. So there the problem arose because of this technological thing, they were not able to do it. Supreme Court said nothing doing. Because of your fault, the SSCs cannot suffer. Anyways. Okay. You want to bring it by way of an affidavit or what?
My lord, she will see, they said that my lord, it is PRC one, but I was not supposed to place it, my lord. When we placed it,
Really?
not the proper instruction.
Yeah, Mr. B. Gugoi, the learned counsel submits that he has received the instructions and would like to file an affidavit to list this matter again on 6/11/2024. Post. The affidavit be filed by 4/11/2024 without fail. So it is observed and directed, observed that in the circumstance no affidavit is filed, this court shall take up the instant petition for disposal on the basis of the materials already available.
Pending item 25.
Not to order, my lord.
There are all 2020 orders.
22, my lord. 23, my lord.
Two lakhs, na?
2 lakhs, my lord. 1 lakh received, my lord, but there will be brothers, my lord. Brothers
Saying
of
that
the-
on account of his elder son, he had already received 1 lakh. In terms of the office memorandum, the father is entitled to 2 lakhs. Thereupon, ekon milai mili likhi dibo. Next, disposed.
Obliged. 2 brothers, and here will be 4 lakhs.
Huh?
4 lakhs,
There are 2 persons.
2 persons.
Why you are filing one petition?
No, own brothers, my lord. Own brothers, same family.
2 lakhs.
Obliged.
The brothers.
Production list item 1.
But this is the matter, about 3 days back, my lord. Regarding installation of a transformer. Yeah.
Who is paying for BSNL? I think your production is क्या है? List this matter. Production list क्या है बोला? Which one? किती average? कौन किती average? Production list का आज average. List this matter again on 3/10/2024 at the top of the list.
34.
Yes.
On the last occasion, on 11/9, my lord, lordship of this pardon order.
Oh, this one.
Yes.
Yes. Why you are not listening to your commissioner? The district administration does not want to listen to the commission.
Yes. We're still waiting for the instructions.
Well, we'll see the face of the district. Who is not doing it?
Madam, District Commissioner.
District
Page
commissioner.
16.
Okay, we'll see his face tomorrow in the morning, 10:30. This is a simple thing where there is a specific direction by the commissioner. Why is the district administration not losing it? It clearly shows the food and Food, Civil Supplies, Affairs and had directed the District Commissioner to take necessary action regarding reinstating issuance of fresh license for the fish, taking into account the convenience of the fair shops.
Page 45 is the document, my lord, by which notice was issued after cancellation of license. Worship, kindly see page 45.
No, that I know, but you are not on that, no?
Yes, yes, I'm not on that. After that, I file appeal. Then my lord, order was issued.
Mr. H. Sharma, appearing on behalf of the district administration, submits that he has not received instructions from the district commissioner Karimganj. Proceed. It appears that this court had only inquired as to why the district commissioner Karimganj have not taken note of the order dated 6/3/2024 issued by the Commissioner of Food, Civil Supplies, Consumer Affairs and Legal Metrology, Assam. First, list this matter on 4/10/2024 at 10:30 a.m., wherein the district commissioner shall be present through a video conference, or you want to obtain instruction.
One chance may be given, Lordship.
On
Already we have
4/10/2024 at 10:30 as the first item
Let it be at 2. Let it be at 2.
at 2 p.m. First up, Mr. H. Sharma shall take appropriate instructions as sought for in the order dated 11/9/2024. First. Yes, book.
Instruction was called for. On the page 35.
Yes, Lordship, I have received the instructions
Yes, what is your instruction?
that at the time of acquisition of the land, 7 lesses of, though they have alleged that 1 bigha, 1 bigha 8 lesses of land were acquired, but 7 lesses of land were acquired at that time, Lordship, out of that 1 bigha 8 lesses. And that was as a alitoli, cultivable land. The cultivable land at the time of acquisition of land, Lordship, it was acquired as it was a it is called a halitoli, and 7 lesses of land were acquired, not 1 bigha. But
No,
there,
he's saying only 1 katha, 7 lesses.
yes, Lordship, 1 katha, 7 lesses, but only 7 lesses were acquired.
Then
Thereafter, Lordship, as they are claiming that amount for that 1 katha 7 lesses, so that payment has not yet been made because of that from the parent department, Lordship, that is from the railway. We have not yet received that amount, Lordship. That is the instructions we have received.
you have not
may I
received
take-
the amount for 7 lesses.
Yes,
Why?
only 7 lesses were required, Lordship.
So 7 lesses is
No, no,
how
no.
much?
That they are entitled to, Lordship, but they are claiming that one.
They may claim for a moon also, but you have to pay for the 7 lesses. Why you are not paying?
Instructions, Lordship, it appears that we are yet to get that amount from the railway. So, Lordship, may I clarify that point?
If you are not, why did you at all require? Recently, a very important judgment has come in the case of JMA developers, where the Supreme Court said the state has to pay from its own pocket, and thereafter shall take the money from those people. So you pay it from your pocket.
But you will have to get from the railway.
No, pay it from your own pocket. Otherwise, it's a violation of 300A. Pay it. That's the Supreme Court judgment. Recent.
Let me clarify this point also. Whether the amount has already been.
Is a judgment by Justice Pardiwala. Very recent judgment. Not done. In fact, this judgment is very relevant for one purpose. This judgment which I am referring to is a very relevant judgment for one purpose, that we see out here the government is taking, oh, they will pay money, then we will do it. Nothing doing. It was made very clear by the Supreme Court. These are cases where you need to quash such amendment then, because it's a constitutional right being taken away, return the land thereafter to acquire again freshly in accordance with. You want to do that? To set aside that.
Lordship, let me clarify whether this amount is with
We
us or
are not concerned. When you take somebody's land, you have to have the money or don't have it money, don't do it. Mr. H. Sharma, the learned counsel appearing on behalf of the, and no railways also. Also heard Mr. H. Sharma appearing on behalf of the state respondents. None has appeared on behalf of the railways on call. This is a case wherein the petitioner's land have been acquired, have been taken over by the respondent authorities without following due process. It has been submitted by Mr. H. Sharma on instructions that not one kata, but 7 letters submitted that only 7 letters of the land of the petitioner have been taken, and not 1 kata 7 letter as alleged in the petition. However, he duly admits that the payment of the 7 letters have not been made to the petitioner on account of the fact that the railway authorities have not made the payment.
Lordship, that part may not be.
You say it now.
It is not reflected in that way.
Then
The petitioner, but because of the unjustified claim of the petitioner, the same has not been done till today.
then why you are not making the payment offer? You have to make the offer. Then he may very well go and say that no, my entitlement is there. Then there will be a reference case. Otherwise, this court is to adjudicate a 300A.
Lordship.
Then what to do?
Yes,
Return the land.
That is why Lordship, during this period, let me get the petitioner. So if it is lying with us,
He have submitted that it is not 1 kata 7 letter as alleged, but only 7 letters.
1 kata 8 lesser.
They are alleging 1 kata 7 letters.
8 lesser, not 7. 1 kata 8 lessers and
What 1 kata? Everywhere it is 1 kata 7 lesser. Your instruction is 1 kata 8 lesser. Everywhere see in his prayer.
yes, 1 kata.
Then
Yes.
and not 1 kata 7 letters, but 7 letters of the land of the petitioner have been taken. It is, however, made clear, he, however, has instruction that the said amount pertaining to the 7 letters have not been paid to the petitioner. List this matter again on 11th of November 2024. The railway administration as well as the district administration are directed to make payment of the land admittedly, which they have taken to the petitioner. The petitioner would be at liberty to accept the said amount under protest. Further consideration, the take the money under protest.
6.
Mr. D.P. Bora, where is he?
Before the division bench in court number 7, Lordship. Lordship, as per order dated 13/9/2024, passed by your Lordship, government was supposed to file affidavit, Lordship.
In this Lordship regarding that.
Oh, Rasut.
Yes, Rasut.
Then
We have received the instructions, Lordship. They are praying for some time as because they have already communicated with the GP secretary regarding their
as because it was stated that those shops were
Eh?
constructed by.
You,
They're still
you
there.
only stated that you needed some order. I gave you an order. Now they are in sixes and sevens. They are confused what to do. On one day, they were very clear that this is rust there. Now see, the council appeared, Mr. H. Sharma, the learned counsel appearing on behalf of the district administration submits that some more time is required so that the verification as directed by this court dated 11/9/2024 can be carried out. This matter again on 13th of November 2024. No, we'll have it before that. 23rd of October 2020.
23rd of October.
23.
37.
Hmm. Closed? Have you
Officer issued them.
done?
I served a procurement.
And one order dated 21/8/2024.
Direct the respondent motivated not to carry out any demolition until an order is passed under section 1. Notice under so and so was served upon the road asking you to discontinue the seat of the zones under the.
Like it was already.
Is government land? No, your land. So you have no permission.
No problem.
Then what happened?
And
Have you sought for regularization?
yes.
Then what happened?
I have already drawing completed. Now some land document is required to file that. I apply the copy, apply the.
Mr. P. Naik, the learned counsel appearing on behalf of the GMC had submitted that that the order submitted that prior to the filing of the instant writ petition, an order was passed on 21/8/2024, which was, however, not brought to the notice of this court, isn't it? The said order is was produced and is kept on record and marked with the letter X. Just taking into account the above, this court, taking into account the above, the observations made in paragraph number 10 of the order dated 13/9/2024 shall not further apply inasmuch as there is already an order passed under section 337 bracket 3 of the Act of the James Guwahati Municipal Corporation Act 1971. When do you want the matter? Okay, list the matter of the permission.
Now we are free.
Eh?
We are free to.
I made it clear.
Item 50.
In fact, you have, Mr. Counsel, you have suppressed that aspect. Today, I'm not in a bad mood for.
Not given to us.
Yes, this is an important matter. What has happened? An appraise as to whether it is permissible to have a commercial shop within the boundary. Where is this government? PDAS. And who appears for the education department? Anybody? Yes, madam, where are you? What? You can have shops.
No. It has not been permissible because the education atmosphere will be hampered.
Detailed report in respect to the above matter has already been sought for from the inspector of schools by the Imam. Where is the second page?
This is the only communication letter sent to the inspector of school for detailed report.
23/9/2024.
Yes, Your Lordship.
They mentioned that commercial shop is not permissible in the premises of an education and the installation of IA will hamper the education and therefore in the interest of the student, petitioner so and so cannot be allowed to continue commercial shops in the environs of Guwahati Madrasa High School, and as such the claim is found to be liable. With reference, I will demand to request you to furnish a detailed report. You are running?
I'm claiming my right under section, what's it, 10.
Mr. Council, having a shop.
Admittedly, I'm running, but lordship 99, kindly look into
95, well, let it be. You better go and get it. Stay before the division ends. See here, this board did not listen to all
Lordship,
this.
kindly,
The staple and the
kindly look into section 10, lordship.
absolutely no.
Lordship, in fact, there are separate boundaries,
A
lordship.
shop inside of the
Lordship, there are separate boundaries, lordship. I have specifically pleaded, lordship.
within the campus. Yes, finance. Do you permit shops inside the well, these madrasas have been provincialized. It is government land, and now you are having shops. It's permissible inside the provincialized the madrasas. Nowadays, the madrasa is also gone.
Yes, lordship, but the repeal act has already, there is a saving clause, lordship.
They saved all the shops.
Lordship, kindly, may I read section 10, lordship? The vested right of the land and building has been given to the madrasas, lordship.
Now, whether madrasas are there or not?
Yes, madrasas, lordship, in fact,
Are the madrasas there now?
lordship, there is a, though the act has been repealed, lordship, but section 2(1).
There's no madrasas nowadays. After that, the year has been done.
Lordship, but section 2 subsection section 2 subsection 2 says that notwithstanding such repeal of the act as mentioned in subsection 1 above, anything done or action taken under the act so repealed before the date of commencement of the repealing act shall be deemed to have been validly done or undertaken by the repealed act.
Oh, this is too far-fetched the submission.
My submission is, lordship, that under section 10 I am protected, lordship.
We do one thing very well. This agreement was of 1995.
1990, 1969, 1969 also there, lordship.
Fantastic. Now, these are all unregistered agreements. We will consider you to be monthly tenant. The tenancy cannot be given by anybody else. And therefore, do we have no right on the basis of these documents?
Lordship, that at the time of execution of these tenancy agreements, the property belongs to the madrasa.
So what?
Lordship,
Now Madrasa wants to throw you out.
prior to provincialization of the
Absolutely
schools,
no.
prior to provincialization of the
I have
schools,
heard Mr. D. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Ms. P. Das appears on behalf of the Ms. P. Das, the learned standing counsel of the Department of School Education, bracket secondary. Pursuant to the order passed by this court on 25/9/2024, Ms. P. Das has submitted an instruction issued by the Director of Secondary Education wherein it has been mentioned, at least before this court, an instruction issued by the Director of Secondary Education wherein it has been mentioned that commercial shop is not permissible in the premises of an educational institution, inasmuch as installation of a commercial shop would hamper the educational atmosphere of an institution. It is also mentioned in the said instruction that a detailed report in connection with the matter have been sought from the Inspector of School, KDC, Panbajar, by the communication dated 23/9/2024. The said instruction is kept on record and marked with the letter X. This court, therefore, adjourns the matter again to be listed on 20/11/2024. In the meantime, the report be submitted, the report of the inspector of schools to be, which have been directed by the communication dated 23/9/2024 be placed before this court. Interim order passed early shall continue till then. But you don't have a case. During the puja, you remain.
For orders, item 38.
Here the respondent was suffered an arbitral award. They filed a repetition challenging the award as well as, my lord, the order passed, my lord, under order 2158, attachment, my lord, determining the attachment. Against the award, they have not filed any appeal setting aside the award. And that order 2158 also, there is.
You have filed an IE?
Filed for interim, there was an interim order for modification of vacating bill. That.
Then what happened?
My lord, there, my lord, there was some negotiation. They were not there. They
Award passed by whom?
they are, my lord, that under the MSME, my lord, facility council. That was transferred.
And that
here.
has been challenged here.
Yes, my lord.
Oh.
No, my lord, no setting aside, my lord. Nothing was. And the order 2158, there is a provision for appeal. That also not been taken this way.
But the interim order has not been extended beyond that.
That is not, but my lord, in fact, there were, in the meantime, some payment has been made, but not all. That's why, my lord, they could have made order 21.
Okay, we will take a why the matter has come up. Service is complete in respect of respondent number 1. That's all.
That's all, my lord. In fact,
We'll list this matter here. Service is complete.
that's right.
Okay, we'll list it for admission, hearing, for stay vacating.
My lord.
Stay vacating. Stay
No, like-
vacating, nothing remains.
Stay vacated. Stay, if
no
the stay is
stay.
vacated, then we'll have to go, my lord. Then otherwise, your lordship will have to hear the whole matter, my lord. But that the read petition is maintained, if not.
What do you want? We'll put it as a stay vacating.
That should be a stay vacating, or not, if your lordship vacates the stay, then.
No, stays has already been
That's fine,
vacated.
but there is no order where that the land executive will not proceed further.
Because if I direct that the stay vacating application be decided, then obviously it means that there is a stay.
The lordship is right for that, but the orders will not weigh heavily with the executive board, as per any order passed by this court.
It is seen from the order dated 26/5/2022.
We have received a communication from the respondent company that the outstanding payment has been made.
No, it's not that. In fact, we have immediately, in fact, there's made.
No,
some-
it's okay. There's no stay. It is seen from the order dated 26/5/2022 that there was no extension of the interim order. Stop. Accordingly, the interlocutory application being IAC 514/2018 does not further remain and it is no longer required to be adjudicated inasmuch as there is no interim order. In that view of the matter, the I stands disposed. Main petition of the House. It is seen that there is a requirement, Mr. P.K. Roy, Mr. P.K. Roy, the learned senior counsel appearing on behalf of the respondent. Respondent number?
Respondent number 2.
2.
2.
You are appearing for whom?
For the respondent number
goodness.
2.
You're not aware.
Respondent number 2.
Appearing for respondent number 2 submits that the matter requires an early disposal. Accordingly, list this matter on 6/10/11/2024 in the admission stage.
39.
complied?
No.
Here, my lord, I am appearing for respondent one, my lord, the principal secretary. My lord, that proposal has not been forwarded by the office of the deputy commissioner, my lord Golaghat. And my lord, we have received in the meantime, my lord, some instructions which say, my lord, with regard to, my lord, the next of kin of the person concerned, there are some disputes. And accordingly, my lord, the superintendent of police, Golaghat, has been, my lord, instructed for submission of a detailed incident report. Number one, my lord.
Next of kin is given by whom?
Next of kin is given
District
by the
Commissioner.
office of the circle of
District
district commissioner.
He has already given.
No, yes, my lord, but one another thing is there, my lord, that with regard to the incident, the accident itself has, my lord, been clouded, my lord.
Then you have to file a review.
Yes.
You have not filed a review. You can't say all these things.
So only for that reason.
Earlier you come up here and say that look here, I am the commissioner and secretary to the government of Assam, principal commissioner and secretary to the government of Assam. And my orders are as per the Assam Land and Revenue Regulation, as per the settlement rules and everything the district administration is required to hear. That's law. But look here, in practicality, nothing is happening because the DC out here does not hear what I say. This was your submission in long and short last time on 22/8. Mr. J. Hendrick, the learned counsel appearing on behalf of the respondent submits that the Revenue Department cannot proceed with the finalization of the verification without the District Commissioner of AI initiating the proposal. However, this court finds no affidavit being filed along with any documents to show the respondents have duly asked the District Commissioner for sending the papers for due compliance to the AI. Now, who is filing this additional affidavit filed by you? There is no affidavit filed by you. Then, okay, we initiate contempt proceedings against them.
The state of, my lord, the communications received, my lord.
Has the contempt proceedings been initiated?
Contempt notice, my lord.
No. Notice. Why contempt proceedings should not be initiated? It is seen from the records that in spite of
I have the written
notice being
instructions
issued,
with me, my lord.
there has been.
I have the written instructions.
No, I'm not going to go by the instruction. This is a contempt matter, Mr. Gopal Pujari. It is seen that this court had issued notice on 19/12/2023 on 15/3/2024. On various occasions, the respondent number one, the respondent is represented. But however, no affidavit has been filed. It is also apparent that there is no compliance to the judgment and order passed by this court dated 28/7/2023 in WPC number 2239/2023. Accordingly, this court issues notice upon the respondent, making it returnable on 2nd of December 2024, thereby asking the respondent to show cause as to why contempt proceedings should not be issued against him. As Mr. Arbor Pujari, the learned counsel, represents the respondent, he accepts the notice on his behalf. The respondent herein, the respondent contender herein is given the liberty to file reply. He is given the liberty to show cause as to why contempt proceedings should not be initiated against him on or before 29/11/2024. Hmm.
Change to fund number 1, 2, and 3. Lordship instruction not been received. Lordship,
What? Why the matters come?
With respect
Service
to
complete.
remaining responsibility.
Service complete.
Complete.
Service complete is the matter for admission after vacations.
But any date may be fixed.
Huh?
Any date may be fixed if possible, because we are.
We listed for every admission on 6th of November.
Obliged.
Yes, Mr. Dinath. Content complied.
Yes, the cases direction has two parts. Number one is kindly similar, the direction. It has two parts.
Complied or not?
I don't know. So for the first part is, first
Not
part is-
complied?
What is two parts by taking lots.
Huh?
First
The
part is
director
compliant.
might not be complied in respect of, as per the.
You have filed affidavit. You want to file reply?
But,
Mr.
just for
R. Fukon submits that he would file reply to the affidavit filed by the respondent number 1.
But one has complied the order. Now the payment is to be released. He has already asked for the payment from the department concerned. That payment here, the amount is not deposited to him. Kindly come to paragraph 4 of the order.
Where is that order passed by this court? Page? Respondent number 6 is directed to make a fresh land valuation with regard to the rate of compensation payable to the writ petitioner. Isn't it? In Hailakandi, by classifying the land into or RIA categories, the making of the demand of the land valuation report by the in terms with arbitrators shall be made within 3 months from the date of a receipt of the certified copy. The payment of compensation of the new land valuation, if any, should be made to the writ petitioner thereafter within a period of 3 months.
Well, this reclassification has been done, and now the reassessment, re-evaluation has been done.
Okay,
Kindly, Lordship,
submits that I have
Page
submits
98.
that he would like to file a reply to the affidavit filed by the respondent number 1. This matter again on 18th of November 2024. Full stop.
Now the PWD department, they said, as per the direction, they have asked for the amount from the PWD department. PWD is not a party here. The deputy commissioner is not, he has complied.
We'll see. Let him file a reply.
Lordship, hold on.
Pursuant to notice of this honorable court, in this case, part payment has been already been, a letter has been communicated, but the payment has not been solicited. Right?
You have got 1,40,000. How much amount do you have got?
I have not got any payment, but a communication has been made to the effect with regard to payment.
It's ready, Lordship, for 50%, Lordship. And
Huh?
Only 50%.
the remaining will be made within one month, Lordship. Remaining payment will be made within 1 month.
Where is it mentioned?
Therefore,
It has been submitted that pursuant to the notice dated 38/2024, that an affidavit has been filed by the respondent. Pusto. In the said affidavit, it has been mentioned at paragraph number 4 that a check of an amount of rupees 1,43,721 have already been issued in favor of the president and secretary of the committee after deducting the labor cess and forest royalty at the first installment, and the remaining amount shall be paid within 1 month. Full stop. The counsel appearing on behalf of the petitioner submits that the petitioners are yet to receive the amount. Full stop. He, however, has no instruction as to whether the petitioners, the president or secretary of the petitioner, had approached pursuant to the communication dated 21/9/2024. List this matter again on 2nd of December 2024 on to provide an update as to whether the entire amount has been duly liquidated. Who died?
On the petitioner,
Why? What is this type of filing application 22-9? What is this?
substitution. and
22-3? And who died? What are you doing?
The petitioner,
What was the cause of action?
lordship,
What are you challenging?
we had challenged the action of the respondent entering into the land of the petitioner.
Declaring the impugn action as illegal ultra vires here. What is the impugn action?
Lordship, will come
The control and possession of the petitioner over the land in the even land when the subquarter is located in so and so. Huh? What is your case, madam?
Lordship, there was a plot of land
Hmm.
at measuring 2 kathas in Dag number 406844.
Does the cause of action survive after the death of the petitioner?
My lord, because he has his legal heir, his wife is there. And
It has heard Ms. P. Chaudhary, the learned counsel appearing on behalf of the petitioner. The above two applications have been filed for setting aside the abatement as well as for substitution of the legal representatives of the petitioner who expired during the pendency of the incident petition. It's the scene that the petitioner, where's the death certificate?
the next again.
Where?
Lordship will find it at IA 1874.
Page 10.
IA 1874. This is
Expired on-
served upon us.
Expired on 14/1/2024, isn't it? First, taking into account that the cause of action in respect to the instant petition survives post the death of the petitioner upon the legal representatives of the petitioner, this court is of the opinion that the instant application, the instant petition can further and can be permitted to be proceeded with through the legal representatives of the petitioner. So it is mentioned that the petitioner is survived by who?
Wife,
Where?
lordship,
He is survived by his wife. That is Sohang Sang Punki. Who is the applicant in the instant proceedings. Taking into account the above, this court substitutes the original petition. It substitutes the applicant with that of the original petitioner. A fresh memo of parties is filed before the registry of this court on the basis of the instant order. And main petition the matter be listed for admission immediately after the vacations. I exposed.
44 and 45.
I appear for respondent 6, my lord. We ask for one.
Where?
the IS.
Num to in golden letters with periods.
Much open.
Yes, what is this? Ali. Oh yes, what has happened?
We have been directed to the
Why the matter has come up for admission, yeah?
The cases were registered. The cases were registered on 7/9/2024.
Why so late?
After
When this court inquired.
no. After the
No, it was registered on, this court passed the order on 6/9, and this is why. This is why this has happened. And what is the update?
The update of the investigation, I have visited the place of both the cases and drawn up case map of the place of occurrence. I have recorded the statement of the complainant.
Again on 8 11/2024. In the meantime, the investigating officer of এই দুটা বুকু কেছ নাম্বাৰ আছে হা দুটা বুকু কেছ আছে দুইটাতে এইটোত যোনটোত আছে এইটো 405 আৰু এইটোত হ'ল 406 নে কিবা আছে দুইটাতে বেলেগ বেলেগ লিখে self directed to file an affidavit bringing on record the present status as on the date of filing of the affidavit.
I'm obliged.
Exceeded on.
8/11.
I'm obliged.
On the date.
What is it?
In this case, as per office note, service is awaited.
Service awaited. Service is awaited. No affidavit has been received in the section. Service is awaited against whom?
6 and 7.
Okay, service is awaited against respond number 6 and 7. List the matter after completion of service.
Obliged, Your Lordship.
51.
Who is the paying? Gogoi, PHE. Hello. List this matter again on 3/10/2024 at 2 p.m.
Possible.